All right, good morning. It's Friday, June 22nd, 2026, 9 a.m. My name is Matthew Sagsby, and I'm be the hearing officer for the hearings this morning. And we are in the hearing room for the Department of Mineral Resources, Oil and Gas Division. And on the docket this morning, we have 5 cases. First case is case number 32730. Before I read the captions, council or any interested parties want to come forward and let me know if there's going to be any consolidations on any of these first few cases this morning.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Lime Rock Resources 3A LP. Mr. Examiner, I'll have 3 witnesses testifying in this case. They're all here in the hearing room. And with respect to consolidation, the 2 Phoenix cases immediately preceding this in the docket, 32925, 32926, are both spacing cases that offer competing spacing with the Lime Rock spacing, cover some of the same lands. So for purposes of hearing, it would be, in my opinion, that it would be most appropriate to hear those 3 cases together consolidated.
Good morning, Mr. Examiner. Aaron Beaver, P.O. Box 1017, Saratoga, Wyoming, appearing on behalf of Phoenix Operating LLC in these matters. I'd agree with Mr. Mann that because Phoenix's 2 applications, 32925 and 32926, wholly overlap with Lime Rock's application, they should be consolidated for hearing.
Okay, with that, we will consolidate case number for hearing case number 32730, case number 32925, and case number 32926. Case number 32730 is a continued application of Lime Rock Resources 3A LP for an order amending the applicable orders for the Diamond Bakken Pool to establish 6 overlapping stand-up 19-20 acre spacing units described as sections 1, 12, and 13, sections 2, 11, and 14, sections 3, 10, and 15, sections 4, 9, and 16, sections 5, 8, and 17, and sections 6, 7, and 18, Township 160 North, Range 91 West, Burke County, North Dakota, and authorize 4 horizontal wells to be drilled on each such unit or granting such other relief as may be appropriate. Case number 32925 is a continued application of Phoenix Operating LLC for an order amending the applicable orders for the Diamond Bakken Pool to establish a laydown 2560 acre spacing unit comprising sections 7, 8, 9, and 10, Township 160 North, Range 91 West, in Burke County, North Dakota, and authorize up to 4 horizontal wells to be drilled in such unit and or granting such other relief as may be appropriate. Case number 32926 is a continued application of Phoenix Operating LLC for an order amending the applicable orders for the Diamond Bakken Pool to establish a laydown 2560 acre spacing unit comprising sections 15, 16, 17, and 18, Township 160 North, Range 91 West, in Burke County, North Dakota, and authorize up to 4 horizontal wells to be drilled in such unit and or granting such other relief as may be appropriate. Mr. Mann?
Yeah, thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota. I believe I did make my appearance in 32730 already on behalf of Lime Rock, but I am also appearing on behalf of Lime Rock in 32925 and 32926. The Phoenix applications, Lime Rock does object to the spacing and the requested relief in both of those cases.
Okay. Mr. Mann, you may call your first witness.
Okay. First witness is Michelle Phillips.
All right, Ms. Phillips, could you raise your right hand, please? Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Thank you.
Michelle, can I just state your name and then tell us by whom you're employed and what capacity, and give us your business address?
Sure. My name is Michelle Phillips. I'm the Vice President of Land at Lime Rock Resources. Our business address is 1111 Bagby Street, Suite 4600, Houston, Texas 77002.
Okay. And Michelle, have you previously testified before this commission?
It's been a minute. It's been about 10 years ago, but yes, I have testified before.
Sure. With it being a while, maybe we can just refresh the commission's recollection with respect to your qualifications. You want to just briefly take us through your educational background and then relevant work experience?
Sure. I did my undergraduate work at Georgetown University. I had a BS in Business Administration. I did my JD and my MBA at the University of Oklahoma. And since graduating from there, I've worked in the oil and gas industry for 19 years.
Okay. And are you familiar with the land matters that are associated with the 6 requested 1,920 acre spacing units?
Yes, sir.
Okay. I'd move the testimony of Ms. Phillips be received as that of an expert.
Any objections?
No objection.
Motion's granted.
Michelle, let's begin with exhibit number 1. And if I could just have you take a look at that exhibit and describe for us the area of the proposed spacing units you're requesting.
Sure. We're requesting to space 3 mile spacing units in the north half of 11691. So it would be 3 mile laterals that go that are stand up that comprise of sections 1 through 18.
Okay. Let's move on then to exhibit number 2. And for the record, can I just have you go through this exhibit and identify each of those 6 1920s you're asking for?
Absolutely. They're indicated in the map in different colors to make it easier to see. 112 or sections 1, 12, and 13, sections 2, 11, and 14, sections 3, 10, and 15, sections 4, 9, and 16, sections 5, 8, and 17, and sections 6, 7, and 18.
Okay. And Michelle, before we move on, it looks like there's some existing development on the majority of these lands where you're requesting the spacing units. Could we just briefly kind of touch on that? Looking at sections 1 and 2, is that a Lime Rock operated unit?
Yes, sir.
Okay. And it looks like there's a middle Bakken well on that spacing unit.
That's correct.
Is that an active well?
Yes, it is.
Okay. Moving over to section 3, is that a Lime Rock operated spacing unit?
Yes, it is.
And does that spacing unit have an active Bakken well on it?
Yes, it does.
Okay. Looking at exhibit section 4, is that a Lime Rock operated spacing unit with an active Bakken well?
Yes, it is.
Okay. How about 5 and 6? Is that a laydown 1,280 acre spacing unit?
That is correct.
And is there a Three Forks well on that spacing unit?
That is correct.
And who operates that?
Lime Rock Resources.
And is that an active well?
Yes, it is.
Looking at section 8, is that a Lime Rock operated spacing unit with an active Bakken well?
Yes, sir.
How about section 9? Same.
Same.
Section 10, is there an active well operated by Lime Rock?
Yes, sir.
How about on 11?
Same. Also an active Lime Rock well.
Section 12, is that an active Lime Rock?
Yes, it is.
Section 13?
That is also an active Lime Rock well.
Okay. How about in section 14?
Same. Active Lime Rock well.
Section 15?
We also operate an active Lime Rock well on that section as well.
Okay. And how about section 16?
Also an active Lime Rock well.
Okay. So if I've counted correctly, it appears that there's 13 active wells that Lime Rock operates on these sections.
That is correct.
Okay. To your knowledge, does Phoenix have any operated acreage in these lands?
Not in the north half of 11691.
Okay. Can you show me how many wells does Phoenix operate on these lands?
0.
Okay. Let's move on to exhibit number 3 and start going through what your working interest is.
Sure.
In each of these. So go ahead on. What's your working interest on that easternmost 1920?
Yeah, so we're talking about sections 1, 12, and 13. We have a 69.89 and some change percent interest in that particular DSU.
Okay. Moving on to exhibit number 4. What's your working interest in that next 1920?
So 2, 11, and 14, we have a 94.689% working interest in that proposed DSU.
Okay. And then on exhibit 5, the next westernmost 1920.
So we're speaking about 3, 10, and 15, and Lime Rock's working interest for that proposed DSU would be 96.825%.
Okay. And then moving to the west again, exhibit number 6, that 1920.
4, 9, and 16, we Lime Rock has a 77.019% working interest.
Exhibit number 7, next 1920.
5, 8, and 17, Lime Rock has a 65.082% working interest.
And then finally, the westernmost 1920, exhibit number 8.
This would be 6, 7, and 18. We have a 22.986% working interest in that proposed DSU.
And let's move on to exhibit number 9. Is it your understanding that Phoenix has brought 2 cases to establish laydown 2,560 acre spacing units?
Correct. Those are the 2 cases, 32925 and 32926.
And in 32925, I believe they're asking for a laydown 2560 consisting of sections 7, 8, 9, and 10. Is that correct?
Yes.
What's Lime Rock's working interest in that spacing unit?
75.215%.
So if the commission were to approve that application and allow a 2560 to overspace 3 of your operated units, you would have the majority working interest in that spacing unit?
Correct.
Have you done a review of record title to determine what Phoenix would own in that spacing unit?
Yes.
Okay, do you know what that is?
Yes, it would be 430.592 acres, which comes to 16.983069% working interest.
And Michelle, are you familiar with the Commission's rules and regulations with respect to revocation and limitation of permits?
Yes.
So, if these were granted, allowing Phoenix to overspace on top of you, and they applied for permits, would Lime Rock contest those permits?
Absolutely.
So, would you file an application to suspend and, after hearing, revoke those permits?
Yes, we would.
And is it your understanding that in the Commission's regs, there's a presumption that if the applicant seeking to revoke the permits have majority interest, that they should be revoked?
Yes.
Let's look at the southern 2560 that they're requesting, 32926. What's Lime Rock's working interest in that proposed spacing unit?
48.694%.
Okay. And again, if the commission were to approve that laydown 2560, that would also overlap your existing operated spacing units. Would you protest any permits that were requested by Phoenix or another operator?
Yes.
Okay. And what's your working interest in that proposed 2560?
Our working interest is 48.694%.
And has Lime Rock done an examination of record title to determine what Phoenix currently owns in that spacing unit?
We have.
Okay. And what did you find?
It's 587.6826506 net mineral acres, which gives them a 23.1883259% working interest.
And just to be clear, Lime Rock does not want the 2,560 acre spacing units, correct?
Correct.
And to the extent either of them were to get approved, Lime Rock would file objections to and revoke those permits.
Correct.
I have no further questions right after the line exhibits.
Any objection to exhibits?
No objection.
Exhibits are admitted. May cross-examine the witness.
No cross-examination.
Okay, any questions from staff?
Michelle, has Phoenix indicated to you why they're protesting these applications?
I've had discussions with Blair Brummel at Phoenix since March, back and forth. I believe that they want to drill acreage in this area and are pursuing it aggressively.
Even though they have minimal interest?
I'm sorry?
Even though they have minimal interest?
Correct.
Any additional questions? All right, hearing no additional questions. Mr. Mann, we call our next witness.
Okay. Next witness is Ann Winter.
Ms. Winter, could you raise your right hand, please? Do you solemnly swear or affirm under the penalties of perjury that the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
And can I have you state your name for the record?
Yes, my name is Ann Winter.
And then can you tell us by whom you're employed and what capacity, and include your business address?
Yes, I'm a geologist at Lime Rock Resources. I had received my Bachelor's of Science in Geology from Texas A&M University in 2005. I stayed there to pursue and receive my Master's of Science degree in Geology, where I finished in 2008. I have 18 years of experience in the oil and gas industry, 8 of which has been in the Bakken. and I have been with Lime Rock Resources for 4 years now.
And have you testified before this commission in the
I have,
past?
but again, it's been quite a while.
Sure. And are you familiar with the geology underlying these proposed spacing units?
Yes, I am.
I'd move the testimony of Ms. Winter be received as that of an expert in this case.
Any objections?
No objections.
Your motion's granted.
Okay. And let's start with exhibit number 10. If I can have you walk us through that exhibit and describe the structure underlying these spacing units.
Absolutely. This is a map on the top of the Upper Bakken Shale, a structure map. The depths of the Upper Bakken Shale here are about 5,800 to 5,800 to 6,100 feet TVD subsea, or 8,200 to 8,500 feet TVD over the proposed units. I have indicated the proposed units in dark gray rectangles.
Let's move on then. The next exhibit, number 11, looks like a type log. Can you just describe what you're showing us on that exhibit?
Correct. This is the Mariner 1 pilot hole type log in the area. It's along the southern border of our proposed units. Showing here, the Middle Bakken ranges about 40 to 43 feet in this area.
Okay. And let's go on to exhibit number 12. Can you walk us through how you intend to develop each of these 6 1920s?
Yes, we are proposing 4 Middle Bakken wells per section in each of the 1920s as stand-up laterals, spacing 1,200 to 1,350 feet apart, depending on the layout of the unit. I have indicated on here approximate pad locations based on some very preliminary scoping that we have done as a team. Where possible, we do want to utilize or expand on existing pads. And there is infrastructure in this area that we would also utilize as well as we can there. Additionally, we have an SWD active in the area, as well as that Mariner type hole or pilot hole is been drilled as an SWD, but not yet completed. So we'd be able to utilize that as well.
Okay. And would this development result in like a uniform pattern development in this area?
Yes, absolutely. So offset activity has had stand-up 3-mile laterals just south of this area, targeting the Middle Bakken Formation.
Okay.
With a similar spacing.
Sure. And it looks like 15 of these 18 sections are currently operated by Lime Rock. That's correct?
That is correct.
Okay. So with your spacing pattern, you're not going to have to overspace anyone else or cross anybody else's wells.
That's correct.
Okay. Let's move on to exhibit number 13.
Mm-hmm.
Can I just have you walk through that? Kind of explain us what you're showing on that exhibit?
Yes. So we wanted to show what the competing DSUs look like in a map view. So I've got the proposed Lime Rock Resources DSUs, 1920 stand-up DSUs, indicated in the dark gray rectangles, and Phoenix's proposed 2560 laydown DSUs in the dashed red lines here.
Okay. And does Lime Rock have concerns about another operator crossing its active wells?
We do. There are 5 active wells within Phoenix's proposed DSUs. We don't know what their procedures would be and are concerned that they may not do their best to protect our laterals, our existing producing laterals. Whereas as operator, we would do our best anti-collision work to protect the existing laterals in order to be able to bring them back onto production post-drilling the new laterals.
Okay. And having operated the current active 13 wells in these lands and knowing the geology through that, in your opinion, if the commission establishes these 1920s, would that prevent waste and protect relative rights and also prevent the drilling of unnecessary wells?
Yes, we do believe so.
I have no further questions for Ms. Winter, and I would offer exhibits 10 through 13.
Any objection to the exhibit?
No objections.
Exhibits are admitted. Any questions for this witness, Mr. Bieber?
Just real briefly, Ms. Winter, I noticed on exhibit 12, looks like there are little red boxes at the bottom of each one of these DSUs.
Correct.
Are those proposed pad locations for each one of the?
They are preliminarily scoped pad locations.
Mm-hmm.
We have looked at and believe they could work. We would need to do on the ground reviews to make sure that they're adequate. But yes, those are preliminarily scoped.
Sure. And are you aware that the pad locations, each one of them, appear to be right up next to the border of the Lost Wood National Wildlife Refuge.
The box does look like that. We would have to review what offset spacing we needed to for those. Yes.
Sure. No further questions.
Any questions from staff?
Wait, I don't mean to go back, but I just, for point of record, on Exhibit 9, the bottom referenced space and unit size you have is 1920, or the application shows as 1920. That should be 560.
Yeah, that's a yeah.
Just for
My
record.
apologies. That's a typo.
Right, thank you. I just wanted to make sure it's clear for record.
Yep.
Thank you.
And you would be targeting the middle Bakken?
Yes, we would be targeting Middle Bakken only here.
Thank you.
Any additional questions? Great, hearing none. Mr. Mann, you may call your next witness.
All right. Next witness is Jeremy Jones.
Mr. Jones, could you raise your right hand, please? You solemnly swear or affirm under the penalties of perjury that the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Jeremy, can I have you state your name for the record?
Yeah, my name is Jeremy Jones.
And could you give us your, or tell us by whom you're employed, I guess, and in what capacity, and include your business address?
Sure. Yes, I'm employed by Lime Rock Resources. We're located at 1111 Bagby Street, Suite 4600 in Houston, Texas, 77002, and I work as an asset manager for the company.
And Jeremy, have you previously testified before this commission?
I have, but like my colleagues, it's been a little while.
Sure. Maybe refresh us then with your educational background and relevant work experience.
So I received a Bachelor of Science in Petroleum Engineering from Marietta College in 2007. I also have an Executive MBA from the University of Houston from 2016. Overall, I have 19 years of experience across operations, reservoir and management in oil and gas. That includes over 10 years at Lime Rock and working in North Dakota.
And Jeremy, are you familiar with the engineering matters that are associated with the 61920s you're asking for today?
I am.
Okay. I'd move the testimony of Mr. Jones be received as that of an expert.
Any objections?
No objections.
Motion is granted.
Jeremy, let's just want to go through each of these 1920s kind of individually. I think there'll be a lot of overlap, being in the same area, but just walk us through each, kind of summarize the reservoir data and then the economics for each, beginning with the 112 and 13 on exhibit number 14.
Okay. All right. So for the 1920 spacing unit covering sections 1, 12, and 13, what you're going to see in this exhibit in the top box are the general reservoir and geologic inputs that the team has generated. The takeaway from this is that the oil in place is about 15.6 million barrels in the Bakken. We're applying, as you go down to the bottom box, we're applying a 20% recovery factor to show recoverable reserves of just over 3 million barrels. What I've also done here for just overall for the 6 DSU request, I've also looked at the Lime Rock operated horizontal wells that are in those sections of those DSUs, and calculated the expected EUR to generate effectively the recoverable minus what would already be produced without further development. And so that's where you'll see this recoverable reserves number for sections 1, 12, and 13 is just under 2.7 million barrels. So further, with the recovery factor that we're using for the 4 additional wells that we're asking for to be drilled in these DSUs would give us 660,000 barrels per well. And the takeaway here is that at 4 wells, there's more than enough resource to drill these wells. From an economic standpoint, we've assumed a working interest of 100% and an NRI of 80%, just for a fairly common royalty burden of about 20% at a flat price tag of $65 oil, $3 for gas. And ultimately, with a capital requirement of about $9.1 million per well, it's going to give us an internal rate of return at 25%, an ROI of 1.9, and then a payout within about 3 years.
Okay. And then moving on to 15, Jeremy, I think there's going to be a lot of commonalities here, maybe some slight distinctions where you to account for existing development. So I don't think I need you to go through the exact same material you just did, but kind of highlight if there's any distinctions on these on these next spacing units?
Sure. On this next spacing unit, it's the same oil in place calculation. It's the same recovery factor. Where you're going to see the difference is the EUR of the existing wells, and so which is going to be where in the first exhibit was 431,000 barrels. Now it's 401. Again, showing that there's more than enough resource here to drill the 4 wells. We're applying the same capital requirement, and then we get the same economics.
Sure. And then moving on to exhibit number 16, the next 1920.
This is going to be the same thing for sections 310 and 15. The EUR of the existing wells we expect to be 480,000 barrels, leaving us over 2.6 million barrels. And again, more than enough resource here. Same capital requirement, same economics.
And moving on to 17, that 1920.
On this 1920 for 49 and 16, the EUR of the existing wells we calculate to be 390,000 barrels, leaving over 2.7 million barrels, enough resource to drill the 4 horizontal wells. Same capital requirement of 9.1 million and same economic outputs.
And then exhibit 18, the last one. Or excuse, second to last one.
Sections 5, 8, and 17, again, it's a little bit lower EUR from the existing wells, only 257,000. That leaves us just over 2.8 million barrels, enough resources here for the 4 wells. And we have, because of the same capital, you have the same economic inputs.
And then exhibit number 19, that last 1920.
Sure. Sections 6, 7, and 18, the expected EUR here is 82,000 barrels. It's going to leave us over 3 million barrels of recoverable reserves, which is enough for to drill the 4 horizontals. At 9.1 million, it's the same economic outputs.
Sure. And Jeremy, having that operated this 13 wells on these lands and having that knowledge and understanding of the reservoir, through that experience, in your opinion, would the establishment of these 1920s prevent waste, protect relative rights, and prevent the drilling of unnecessary wells?
Yes.
Okay. I don't have any further questions for Mr. Jones. I'd offer the exhibits 14 through 19, as well as we do have a gas capture plan affidavit, exhibit number 20, I would offer as well.
Any objections?
No objections.
Exhibits are admitted. Any cross-examination?
Yes, just real briefly. Jeremy, good morning. When did you acquire all of the wells within the proposed spacing? Or when did Lime Rock?
Sure. It would have been approximately 2015.
And since that time, there's been no further development by Lime Rock?
These specific DSUs, there's been no further development, but to the east, Lime Rock drilled 6 wells, 2 each in 2017, 2018, and 2019. So in what we would consider the Dimon asset area, we have been active since we've bought the asset.
Sure. And how many 3 or 4 mile wells has or Lime Rock hasn't drilled any 3 or 4 mile wells in the Bakken so far, correct?
That is true.
And currently Lime Rock has no rigs running in the Bakken, correct?
That's true.
When do you plan to develop the wells that are the subject of this proposed spacing?
Sure.
Mr. Examiner, I think we do have an answer to that question, but Ms. Phillips, I think, is the best witness to address the timing. So
how about if you finish up your cross, and then is it okay if Mr. Mann recalls his previous witness?
Sure.
Or he can put her on redirect. It's more
That's fine.
timely to do it now.
That's fine.
Okay, so do you have any more questions of those witness?
No.
Any,
Well, I mean, I still have a pending question.
sure,
Yeah.
I understand.
Yeah.
So before we move on, any questions from staff?
You have some questions to the way the economics are laid out here. I just want to make sure every rate of return is 25%, and the payout and the return on investment are the same. So did you back into that number, or what are the actual recoverable reserves on a per well basis of a 3 mile well in this area?
Sure. Yeah, what we're assuming here, based on our type curve work, you'll see in this lower box, the recovery per additional well is 660.
Which box are you looking at?
Oh, I'm sorry.
Page.
Yeah, we can look at sections 1, 12, and 13.
Okay, got it.
Apologies.
Yep.
And so So in the lower box here, you'll see the 660 number. What we're calculating from our type curve work is that a 15,000 foot Middle Bakken well would produce 660,000 barrels. It's also 44 barrels per foot. And so we did this work independent. This is kind of the point I want to make here too, is that we've done this work independent of what was already produced. We've looked at the normal type curve generation type process, and that's why we then went back in and looked at what was the resource that was available, what's already been produced, and that's why we're confident we can go drill these wells, get the 660,000 barrels, because we've done this independently, as opposed to saying that X amount is available, we've already produced so much, and so we'll just divide that by 4. That's not the process. We've done it the other way with a fully engineered report to say we can get the 660,000 barrels per 15K lateral.
So 660,000 barrels per lateral relates to a 25% IRR and the 1.9 they have over 36 months.
That's correct.
Okay. Thank you. And then I guess maybe it's a question for the next witness, but typically I ask this question of the engineer, but when's the planned development date for this area, all 6 basin units?
Mr. Anderson, I can recall Ms. Phillips to address that.
Thanks.
Any additional questions from staff? Okay, so Mr. Beaver asked the question that Mr. Jones could not answer. So I think what I'll do is allow Mr. Beaver to address that question to Ms. Phillips, and then you can follow up if there's any need for clarification.
Understood.
Yep. Sure. The question was, when does Lime Rock plan to develop these wells?
2027.
Any additional questions?
No.
Any follow-up, Mr. Mann?
No follow-up. Thank you.
Any additional questions from staff? All right, hearing no further questions, do you have anything else for these consolidated cases, Mr. Mann?
Not at this time, Mr. Examiner.
Okay, Mr. Reaver, you may call your first witness.
Yeah, if you just give us a moment to shuffle here. Yeah. Yeah, here. You can. Do you have? Yeah, she'll have it.
You have your own.
She'll have it. I had my own, and she will bring you more. Thank you.
Are you ready to proceed?
Yes, Mr. Examiner, just by point of clarification, if we could just hear 32925 and 32926 at the same time as the geology and engineering testimony and exhibits will be virtually identical.
Okay, just so for the record, you anticipate that your direct testimony will be also considered as evidence with respect to 32730 also.
Correct.
Okay. That's so your request should be granted. Will be granted. Are you ready to proceed?
Yes. First witness is Mr. Justin Arndt.
And Mr. Arn, can you raise your right hand, please? Do you solemnly swear or affirm under the penalty of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge or belief?
I do. Justin, can you please state your full name, by whom you're employed, in what capacity, and your work address, please?
Certainly. My name is Justin Lee Arn. My title is Chief Land and Title Officer for Phoenix Operating LLC. The work address is 4643 South Ulster Street, Suite 1510, Denver, Colorado 80237.
And Justin, are you personally familiar with the lands that are subject to these applications,
Yes, I am.
along with Lime Rock's application 32730?
I am.
And have you had your qualifications been previously received by the commission as that of an expert witness?
They have.
Move for Mr. Arn's testimony being received as that of an expert.
Any objections, Mr. Mann?
No objection.
Motion's granted.
Justin, do you prepare to cause to be prepared the exhibits, Phoenix exhibits for this hearing?
Yes, I have.
Justin, just as a general matter, given the commission's rules favor majority working interest owners, and Phoenix is the minority owner in these spacings, why is Phoenix prefer this configuration?
I think as we walk through the exhibits, it'd probably be better as we get to the actual working interest proportion, if it's okay if I answer that
Sure.
question at that time.
Okay.
Thank you.
So, taking a look at Exhibit L1,
Certainly, as we look at Exhibit L1, and I think that the board will be familiar with this, having seen the Lime Rock exhibits just previously. What we're identifying on both cases 32926 and case 32925 are the two laydown 2560 configuration units that Phoenix is proposing here today. You can see that they're laid one on top of the other, directly above the Lostwood National Wilderness. And that's essentially the zoomed out version there of our regional map of that.
L2 for both applications.
L2 identifies the in a zoomed in version for both our Toucan and Flamingo units, again 32925 and 32926. In each exhibit, you can see that the units are identified in a red outline for each one. We do note, of course, that in case 32925, our Flamingo unit, that sections 18 and 17 are non-producing units, non-producing sections. And sections 15 and 16 are in fact producing sections under wells that are operated by Lime Rock. We also note in case 32925, excuse me, I might have confused that. It's the same situation, except that only section 7 is non-producing. Of course, sections 8, 9, and 10 also under Lime Rock producing wells currently.
And turning to Exhibit L3.
L3, we like to identify any state and federal interests within our proposed units, just because it's important to identify whether those are leased or unleased, if it's going to cause any issues with regards to the drilling. Phoenix, in case 32925, our Toucan unit shows no federal or state interest, either leased or unleased, so no issues drilling there. 32926, the same situation. There is actually, of course, that state section 16 that is leased is held by production, of course, by that Lime Rock well.
And turning to L4 in each application.
Certainly. L4, let's start with 32925, the lower of the two. With respect to Phoenix's interest, we're showing Phoenix owns a 21.04% working interest in the unit. Phoenix basically agrees with Lime Rock's interest, being about 75% roughly of the unit. I think that our interest is probably coming in a little higher than what Lime Rock actually witnessed to, probably because we have unrecorded leases at this time that are currently under contract. I don't think that there's any real dispute there, probably. With regards to case 32926, you can see that we actually give Lime Rock, I think, just a tad more than they witnessed to themselves. And we show that Phoenix's working interest in the proposed unit is, again, 39.12, somewhat significantly higher than what Lime Rock testified to. Again, I count that down to unrecorded leases that are currently under contract. Given that Lime Rock was dealing with record title, you can see why there might be a discrepancy there.
Right, and then on application 32926, the proposed Flamingo unit, there's an exhibit L5. You just want to walk us through that?
Oh, of course. Exhibit L6 32926. I'm sorry, for L5 for 32926 shows a letter of support from a non-operating working interest owner, Vierson Oil and Gas, basically supporting Phoenix's spacing unit in this particular case, and outlining their ownership in that proposed unit. So we decided to include that there.
And now I'll circle back to my previous question that I asked a little preemptively. So, given the commission's rules favoring majority working interest owners and that Phoenix is the minority in both of these units, why is Phoenix proposing these or this configuration?
Certainly, I think the best way to answer that question would, for me to answer that question would be to go back to exhibit probably L2, just so that we can kind of see what that looks like. As we look at L2 and Phoenix's proposed configuration there, there's a couple things that stand out to us. First is Phoenix always prefers at this stage 4-mile units to 3-mile units wherever possible. Phoenix has drilled both 4 and 3-mile units. In fact, maybe second most, I think, used to be first most, 4-mile units in the Bakken. At this time, we certainly prefer it for a lot of different reasons. The economics of it, the economics of those wells, we feel are far more favorable. Additionally, it reduces the drilling of unnecessary wells in almost every instance. So wherever possible, we try to make sure that we're maximizing acreage with as few wells as possible, and most especially in an area that might be considered sensitive, or an area that might draw public interest. I'll note that a few days ago that there was actually public interest in these two cases from, I think, a member of the public that was here to speak about the Losswood Wilderness and whether or not either Lime Rock or Phoenix plan to drill under that unit. There's clear interest in this area. And so when we look at this area, regardless of Phoenix's working interest, we believe that 4-mile units and 4-mile laydown units in this area are the most ideal way to develop it. Now, I just want to speak to some of the things that were testified to by Lime Rock, and that has to do with operational control. We agree with Lime Rock's testimony that at least on one of these laydowns, certainly the northern one, there's no doubt about it that Phoenix, in order to be the operator of that particular unit, given Lime Rock's 75% working interest in the unit, would certainly have to work with Lime Rock, or if necessary, Lime Rock would need to drill the 4-mile wells themselves. But I think that we believe that those 4-mile wells would be beneficial for the area and would probably be more economic. So that's the crux of our argument. That's why we're here today. We believe that this is the best spacing pattern for this area and for this unit, regardless of who the operator is.
And Justin, just to follow up on that real quick, surface location, where would Phoenix propose to drill the wells that are subject to these two applications?
Should Phoenix be the operator of these wells, we think that the best surface location would be along the township line there, being on the 6, 7, 18 corridor. We do note that Cord is actually, in fact, I'm saying Cord, it might be Whiting Oasis, different names, hard to say, is developing also 4-mile laydowns going to the west from that same location, from that same sort of area. And we think that that placing those pad locations off to the west, far north of the Losswood Wilderness, would be more ideal and potentially be better for facilities overall between two operators, either of those two operators being Lime Rock and Whiting, or being Phoenix and Whiting.
And Justin, did you execute the gas capture affidavit that's attached as Exhibit E4 to both applications?
I did.
I have no further questions for Mr. Arnn and move permission to the land exhibits along with the gas capture affidavits.
Any objections?
No objection.
Exhibits are admitted. Any questions from staff? First of all, any Mr. Mann, do you have any cross-examination?
Just a few. Mr. Arn, Exhibit L5 32926, that letter of support from
Yes, sir.
Pearson. Were you the one who communicated with Pearson?
I was not.
Okay. Do you know who the person was who communicated with Pearson?
I do. It was our VP of Business Development, Mr. Blair Brummel, who was referenced earlier by Ms. Phillips.
Okay. Do you know if Mr. Brummel indicated to Pearson that Lime Rock was not planning to develop this acreage?
I do not know that.
You don't know one way or the other?
I don't know one way or the other. Well, I think I just said I don't know.
In your opinion, would it be appropriate for representative of Phoenix to be telling a non-op working interest owner that another operator is not going to develop acreage?
Objection, speculation.
Sustained.
Mr. Arn, you indicated that Phoenix always prefers 4-mile spacing to 3-mile spacing. Did I hear that correctly? Or?
We generally prefer it. It's certainly in our configurations, we're always trying to develop 4-mile configurations where possible.
Okay. Would you also prefer 4-mile configurations to 2-mile configurations then?
It depends on exactly what that would look like. So, for example, you can actually drill 4-mile configurations within a 2-mile corridor these days using U-turns or switchbacks, and that can, we believe, yield some of the same recovery as you might from a 4-mile.
So you would do 2-milers, but you wouldn't do 3-milers? Is that what you're saying?
I'm not. I don't think I'm saying that we wouldn't do anything.
I guess I'd have to just object to relevance.
Overruled.
I guess I don't understand the question.
Well, I'm just trying to understand your kind of base. You objected to the Lime Rock 3-milers,
Mm-hmm.
and you've indicated that your preference to drill 4-milers versus 3-milers.
Mm-hmm.
And what's the basis for that?
Well, so generally the basis in this case would be certainly less surface disturbance and the drilling of less wells to yield what is hopefully the same or more ultimate recovery. I think that's one of the purposes of that, and I think that's why 4-mile wells are generally becoming more in vogue. So I think that was the argument that I stated.
Okay. Are you familiar with last June? Phoenix had a contested case with Oasis in the same area. That case was along the western boundary of the Lost Wood Refuge. Excuse me. Do you recall that case?
I wasn't the witness in that case. I do have a familiarity with it. I might not be able to answer all your questions,
sure,
but I have a familiarity.
Yeah. Well, in that case, Phoenix had requested a 3,840 acre spacing unit.
Mm-hmm.
That got denied by the commission. Do you recall that?
I do.
Okay. And did you review the order in that case at all?
I think I did briefly. It's been a little while, so you may have to refresh.
Sure. I think the commission indicated that one of the main issues was that in that case, Oasis had owned the majority interest in the proposed spacing unit. And because of that, and the ownership interest that Oasis had, they'd be likely to prevail in any permit dispute. How is this case different?
As I recall from that order, one of the other major concerns with the board at that time was that Oasis presented an alternative drilling plan that Phoenix could use to access the federal acreage in that particular unit, and they called that out specifically. So they found, as I recall from that order, they found Phoenix's argument that it must be developed this way as unpersuasive in terms of accessing that federal acreage. So, as I recall from that order, it was a 2-part. Usually, I find the commission gives you several reasons, but I think both of those reasons were attached as reasoning for the order.
Well, I think what they found,
Mm-hmm.
and I can tell you what they found. They said that Oasis and the 5 additional owners that opposed the proposed 3840 in the lease line horizontal are very likely to prevail if they apply for revocation of a permit to drill issued in the proposed stand-up lease line 3840 and provided convincing testimony that such lease line horizontal was an unnecessary well. How would Phoenix be able to overcome the presumption in this case that their permit shouldn't be revoked?
Certainly. So Phoenix agrees with majority interest ownership, certainly with regards to permits. So let's say that, and hypothetically, that Phoenix applied for permits on these 4 mile units, and that Lime Rock protested those permits, and those permits were shut down. I think that at that point we would adhere to that, certainly. We'd also ask at that point, when does Lime Rock plan on developing these units themselves? At what point does a non-op that may be a minority working interest owner have to wait for the operator who may or may not have any real plans to develop, whether they're 3 milers or 4 milers? How long must that non-op wait for a held by production operator come to develop their units while the non-operator, who may be a minority working interest owner, has to sit and wait? Is the answer 6 months? Is the answer a year? Is the answer at the expiration of your leases? I don't think that I know the answer to that question, but while we would certainly understand those permits being revoked, I think that certainly a timeline would be attached to that. And as long as the acreage was developed, and hopefully developed in the most economic way, and the way that reduced the number of overall wells in a sensitive area, I think Phoenix would be happy.
Is it Phoenix's position that it's okay for an operator to space over the top of another operator's acreage that has active wells on it?
That it's okay to do that?
Yeah.
In certain instances, yeah.
What instances is it okay to overspace another operator who has active wells on that spacing unit?
Well, in an ideal world, when you've spoken with the operator, you just have no other choice, or also if it's the best development pattern for the area. I don't think that the operator of an old well necessarily that hasn't developed much in the last how many years, that hasn't seemed to show any plans. I don't know that that's ultimately like something that you can't or should not do. I think you should work with that operator in almost every instance, and I think that Phoenix has been attempting to do that in almost every instance, and I think including in this one. I know that discussions between Phoenix and Lime Rock have been ongoing up to this day. So, yeah, hopefully that helps answer your question.
So if another operator went and spaced over the top of some of Phoenix's acreage where you had an active well, would you be okay with that?
Oh, I'm sure we would protest it, just like Lime Rock has protested us.
And are you suggesting, based on your previous response, that uniform on pattern 1920s, consistent with other development in this area, is not the appropriate spacing?
I think it's a form of spacing that could be used. I think that we prefer lay down 25-60 in this area.
Okay, I have no further questions.
Any redirect?
Yeah, just a few. Justin, Mr. Mann asked you about what Phoenix's preferences are with relation to whether it's a 2 mile spacing unit, 3 mile or 4 mile. Are those preferences for Phoenix, whether they prefer a 2 or a 3 or 4 mile DSU in any given instance, are those always going to be fact dependent on each individual case?
Oh, absolutely.
And taking a look at Exhibit L4 on, I want to take a look at Exhibit L4, direct you to that on 32926, that application. Phoenix is shown as having a 3.12% working interest, correct?
I'm sorry, 39 point.
Or I'm sorry, 39.12.
A little better than, yeah.
Right, a little better.
Thank you.
But we still have almost 12% unleased.
Just about.
Is Phoenix seeking to lease those owners?
Absolutely.
And if Phoenix were, let's say, to lease all of those owners, roughly what would Phoenix's working interest be there?
Looks like we would be just over 50%.
Okay, so no owner in 32926 is a majority at this time.
Of our proposed spacing there, no owner is the majority working interest owner. That's correct.
Correct. And just one more quick question. There was some question about whether Phoenix believed these 4-mile DSUs were the best configuration. Does Phoenix believe that these 4-mile laydowns are the best just for Phoenix or for everybody?
Oh, we believe they're the best for everyone in this area.
No further questions.
Mr. Mann, any?
I just need to clarify on Exhibit L4, Mr. Arn. 48.93% for Lime Rock. They are currently the largest working interest owner in what you're proposing in that spacing unit.
Yes, sir.
Okay. And there's zero guarantee that you would get any additional leasehold, correct?
Certainly a possibility, but no guarantee.
Okay. No further questions.
Any questions from staff?
Justin, on your exhibit L5 and 32-926. This letter from Verison. In the third paragraph, it says, as a working interest owner in the above named section. What section are they an interest owner in?
Oh, it doesn't look like it says it specifically on this particular letter. I could find out what section it is. It's one of the Lime Rock sections. They're actually a non-op owner in one of the Lime Rock sections there. So that would need to be, I believe that would need to be, what is that? 15 or 16? Is that right? It's probably section 15. Let me just look. But I can certainly get that information for you to find out exactly where their ownership is. But it's not in any of the unleased sections, I don't believe.
Well, it just seems this letter gives virtually no information. It says it supports Phoenix. It says it's an interest owner. It doesn't state where it's an interest owner. It doesn't state what this interest is. If that's 10% or 0.1%. This letter is virtually meaningless.
I apologize for that. We'll attempt to clean up our support letters, Mr. Bohr. I believe that the working interest ownership of Verison is 40 acres. And if I'm not mistaken, it is in section 15 of the township. So it is, I think, where? Oh, sorry. Yeah, I'm pretty sure specifically it's in section 15. But if I'm wrong about that, then don't hang me.
In these proposed space units, there's 3 producing wells in one and 2 in the other. Is that right?
That's correct. There's 3 producing wells in the northern one, and there's 2 in the southern. That's right. All of those Lime Rock wells.
Hasn't Phoenix testified multiple times that it prefers to establish space units at Virgin Reservoir?
Phoenix has, yes. It's definitely not our preference.
So what's different here?
I think the difference here is that we have 2 competing configurations. None of those configurations, by the way, can you not mix virgin acreage with producing acreage. I know even the far western one that Lime Rock proposed, I think was at 6, 7, and 18, you would still need to mix virgin and producing acreage. And the one immediately to the east of that, again, same situation. There doesn't seem to be any good way to develop all 3 of the non-producing sections without mixing virgin acreage with producing acreage. Where possible, Phoenix will always take the stance of not trying to mix those 2, but I don't see a way to do it in this particular instance with either.
Given Phoenix's acreage position, I mean, why is this of such interest to you?
I'm sorry. Our acreage position where?
And acreage position in these space units and your preference to not space or to space in Virgin Reservoir. Why are you so interested in these spacing units?
So again, as it's our general interest and also always our preference, and very likely always hear us up here making that argument. In fact, you may hear us making that argument later today with regards to not mixing that acreage where possible. If there are alternative configurations. I don't have an alternative configuration that could develop all three sections without mixing that. So in this instance, there's no way around that. With regards to the actual development and why we're so interested, Phoenix does have significant capital investment, near-term, recent capital investment in leases in these three sections. We're very interested in having these sections developed. We'd like them to be developed in the best pattern possible. And we think the best pattern possible is the one that we're laying out. With respect to how that gets or who develops that, certainly Phoenix would like to be the one who does that. We also recognize that we may not be able to be. If Lime Rock does in fact drill wells in 2027, we think that would be great. We'd also prefer that they drill these 4-mile laydowns.
Okay, thank you.
Thank you.
Justin, just a little while ago in your testimony, you mentioned lease expirations as a reason. Is this one of the reasons that you guys prefer to move forward and drill these units?
It's almost always the reason. I don't have a lease expiration schedule. I know we always ask for one, and I can certainly supplement the record with one. Our leases are near-term leases, so in terms of when these leases are expiring, we're probably looking at anywhere between 2028 and 2030 in terms of our expirations. But I will note that all of Phoenix's leases are expiring, every single one of them.
Mm-hmm.
And I'm not aware that any of Lime Rock's leases will expire, given that they're all held by production. I could be wrong about that. They'd have to correct me.
So if Lime Rock drills the wells that like they testified to in 2027,
mm-hmm.
that would protect the leases of Phoenix?
That would protect those leases.
Okay. Thank you.
Thank you.
Any additional questions from staff?
Justin, just real quick on your gas capture affidavit. You're indicating the way you're wording this is that you will speak with a gathering provider in the area, or Phoenix will, sorry. Where's Phoenix's closest gas takeaway or contracts with the capture provider to relevance to these spacing units?
Phoenix doesn't have any operations in this particular area. We work with all of the gas companies and takeaway companies, depending on exactly where we're going to be, and our interests are spread out all over the place, to be honest. So we've worked with One Oak, Steel Reef, all the different operators in the area. I think right now we're in discussions with Argent Midstream to add this location to an existing dedication that we already have in the area to the northwest of here, should Phoenix become the operator of these units. So that's not a given.
So you feel confident that if the commission was to allow Phoenix to be the operator, that you would be able to secure a contract for gas takeaway and not flare these wells?
We do.
Thank you.
Thank you.
Any additional questions? Anything else, Mr. Bieber?
Nothing more for Mr. Arnn. We'd just like to call our next witness, Mr. Lewis.
Mr. Lewis, could you raise your right hand, please? Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Topher, can you please state your name, by whom you're employed, in what capacity, and your work address, please?
Topher Lewis, geologist for Phoenix Operating. Address is 4643 South Ulster Street, Denver, Suite 1510 80237.
And are you personally familiar with the geology matters that are subject to these two applications?
Yes, I am.
And had your qualifications been previously received as an expert witness?
Yes, they were.
I move to have Mr. Lewis's testimony be received as head of an expert.
Any objections?
No objection.
Motion is granted.
Topher, be prepared or cause to be prepared the exhibits for this hearing.
Yes.
Can you please turn G2 and describe G1 on both applications, please?
Yeah, Exhibit G1 for both cases 32925 and 32926. It's a structure map in the Upper Bakken Shale and subsurface TBD, contour interval of 20 feet. In this area, the structure is dipping to the southwest. In addition, on both of these, you'll see a red outline that pertains to both of our spacing units, 2534 and 2535 acre units. Gold line is a two well cross section, highlighting the type well that we'll reference in the next exhibits.
Right. And turning to the next exhibits, G2 on both applications. Can you describe those?
Yeah, G2 upper portion, two well cross section. The curves that I'm plotting are from common triple combo gamma ray resistivity porosity. Black line represents our stratigraphy in the area, and it illustrates that the Middle Bakken and Three Forks are present in the subsurface in this area. And our target for these would be the Middle Bakken. The type well that we're using is the Mariner 1 pH, the same type well for the area that Lime Rock is using. And reservoir properties from that are summarized in the table below, and that's the data that we'll use in the next exhibits.
And Topher, is the Middle Bakken present continuous across the entire proposed spacing units, both of them?
Yes.
No further questions for Mr. Lewis, and move for admission of the geology exhibits.
Any objection?
No objection.
Any cross-examination?
No questions. No.
Okay. And no objection to the exhibits. Any questions from staff? All right. Hearing none, Mr. Beaver, you may call your next witness.
Next witness is Mr. Eric Shivey.
Raise your right hand, please. You solemnly swear or affirm under the penalties of perjury that the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Eric, can you please state your name, by whom you're employed, and what capacity, and your work address, please?
Yes, my name's Eric Shivey. I'm employed by Phoenix Operating. I'm the Vice President of Reservoir Engineering and Corporate Reserves. Business address is the same, 4643 South Ulster Street, Suite 1510, Denver, Colorado, 80237.
And are you personally familiar with the engineering matters that are subject to these two applications?
Yes, I am.
And have you had your qualifications been previously received as that of an expert witness?
Yes, they have.
I move that Mr. Shivey's testimony be received as that of an expert.
Any objections?
No objection.
The motion is granted.
Eric, can you be prepared or cause to be prepared the engineering exhibits for these two applications?
Yes, I have.
And taking a look at E1, can you please explain E1 on both applications?
Yes, these are identical on both applications. It's our standard 3-string casing design. We use in the Williston Basin 4.5-inch liners cemented in place, and we complete 4-mile laterals, typically 100 frac stages via plug-in perf.
And E2?
E2, they're slightly different. I think it's been previously discussed. There's 3 wells in the existing diagonal 640s in the northern unit, and I have those identified cumulative production of oil and gas and water to date of all 3 of those. And it's a similar, if you look at E2 on the next case, 32926, those are the 2 existing wells with cumulative production of all 3 streams. The plan here would be to set back 660 feet from the north and south lines, and that would yield about 1,320 foot spacing internally between the well bores. We would plan to batch drill and complete these.
Sure. And where there's no pad locations that are depicted on either E2, where would Phoenix be placing its pads?
Our preference is we're looking at the western part of that township line. As Mr. Arn said, we would be drilling these from west to east is our plan. We're just in preliminary stages of finding a pad location.
And I believe there was some testimony by Lime Rock geology witness, I believe Miss Winter. She just expressed concern that Phoenix's operations may not, or she was unaware of how Phoenix would go about protecting Lime Rock's wells, existing wells. Can you speak a little bit to that?
Yeah, sure. In this part of the Bakken, a lot of 640s were developed this way with diagonals going across them. Phoenix has done a few of these crossings itself over old well bores. When there's liner in the ground, you got steel, so you can do anti-collision work to avoid that. And then on the other side, when you're fracking, you would offset your frac stages to not, get close to those existing well bores. Skip a few stages, if you will, 2 to 3. So to frack right above that well bore.
Right. So you and your engineering staff at Phoenix feel fully equipped and prepared to protect Lime Rock's wells.
Yeah, we have done well bore crossings before.
Right.
I think to answer your question.
Okay. Looking at E3 on both applications.
Mm-hmm. Yes. So the top table provides our summary of our ARPS equation and EUR for the wells. Note that I did see, I had the benefit of seeing Lime Rock's testimony before they saw mine. I'm assuming 650,000 barrels of oil per 4-mile lateral. I believe their testimony was 660 for a 3-mile lateral. That implies roughly a 43 to 44 barrels per foot. I'm coming up closer with the type curve work with a lot of the wells in the area, around 31 barrels per foot. So that's kind of why my EUR is lower. And I just our experience in this area, as you get into the lower GOR, I'm showing 1,000. I think they showed 730 or 728, something like that. Where I'm going is that's a pretty low GOR. We're shallower. It's a solution gas drive system. So I believe 30 to low 30s barrel per foot is more reasonable for a recovery on a per foot basis of these wells. Also note, like the DSU recovery factor, that includes some of the existing 640s where we be crossing. Their ultimate recovery is kind of included in that DSU recovery factor. And then the economics below, those are identical on both exhibits or both cases. Excuse me. I assume $70 flat WTI, $3.50 Henry Hub. D&C costs of approximately $11.76 million to drill and complete a 4-mile lateral, yields a PV10 of 7.4, 45% rate of return. Then that's an undiscounted return on investment of 2.2, and thus undiscounted payout of 1.84.
So, in comparing Lime Rock's exhibits 14, 15, 16, 17, 18, and 19, Phoenix is getting a higher internal rate of return.
Yes.
On these wells.
Yes. I believe a reason probably is for that. You'd have to normalize to a common price deck. I believe they were running at 65.
Right. Any other comments on how these wells compare economically?
No, that was all I was going to say on that.
And E4 is at the gas capture affidavit testified to by Justin.
That's correct.
No further questions for Mr. Shivy. Move for admission of the engineering exhibits.
Any objections, Mr. Mann?
No objection.
Exhibits are admitted. I may cross the witness.
Mr. Shivy, you're not suggesting that development with 3-mile stand-ups that Lime Rock's proposing is uneconomic, are you?
No, I believe their economics.
Okay.
25% rate of return. They're economic.
Is there some risk to harm to the existing Lime Rock wells by crossing them?
I agree. Yeah, there's it's not zero, but I think it can be minimized because well bores are typically crossed in the Bakken anymore by a number of operators.
Typically crossing their own wells.
Fair. Understood.
What would you do if you impacted or damaged a Lime Rock well when you're crossing it?
There would have to be discussions between both parties at that point. Salvage or some type of that would be beyond my scope, but I imagine there'd have to be some discussions on that.
Okay. Did you consider developing 7 and 18 as a 1280? Excuse me, Mr. Mann. It's two of those open sections?
I see it in the southern part. I don't believe so. No.
Okay, why not?
Just we prefer the that would kind of put like just the configuration there would cause like 5 and 6 to remain a 2 mile, 7 and 8. We were trying to like maximize as many 4 mile laterals as we could in this area,
Do you prefer
and less surface disturbance too.
Do you prefer 4 milers to 2 milers?
Yes.
Okay. I have no further questions.
Any redirect?
Yeah, just real quick, just to be clear, Eric, you prefer 4 milers to 2 milers in every instance, or this specific instance?
This specific instance, yeah, we've drilled a number of lateral lengths in the basin.
No further questions or redirect.
Any questions from staff?
Eric, did Phoenix run its own economics on the proposed 1920s that Lime Rock has, just to see how they would compare to the 2560?
That's a good question. No, I did not.
What's Phoenix's proposed spud date on these spacing units should the commission allow?
Should they allow this? We have the 3 rigs. We're working the drill schedule. I think short answer question, the earliest would be like Q4 of 2027.
You said Q4? Sorry.
Q4, correct, sir.
So you would drill them in the same year that Lime Rock indicated in their testimony?
Yes.
Can you elaborate a little bit on my first question that I asked you as to why Phoenix wouldn't have reviewed that just to see how those economics do compare, being your working interest party in those spacing?
I just didn't do it, and that's something I could certainly follow up with my assumptions and everything and provide a supplemental.
Unless other commission staff say otherwise, I think you'd be okay now too. Thank you.
Eric, Wade, and Aaron, I would like both Phoenix and Lime Rock to submit economics on each other's proposals with a mutually agreed upon price deck. So we're comparing apples to apples.
I understand, Mr. Board.
You can pick Phoenix's $70, $350, or you can pick Lime Rock's, what was it, $65 and $3. It doesn't matter, just so they're the same.
Sure.
Okay, thank you.
I guess to add to what Mark said, there's other factors that change economics, such as the B factor and various things like that. So I think common understanding of the main inputs that impact economics is going to be valued as well. I don't think I wouldn't expect Lime Rock's or Phoenix's operating costs to be exactly the same. You guys have different operations, but certainly all of the other inputs, you guys can terminal decline percentages, those type of things.
Operating expenses.
B factors, that type of stuff. So, thanks.
Sure.
Any additional questions?
I guess with my question there, I'll just state that, went through economics with Lime Rock, and it's really challenging and confusing when we don't see all the inputs to the economic runs, and it's not necessarily our job to do that. But when we see a well that costs more, slightly higher oil price, not sure on the deduct in Lime Rock, and you can just go down the list and say, okay, it's got a higher rate of return, it's a more expensive well. How did that work, right? With lower reserves,
sure.
Right? So that's the reason that we need to kind of level set economics.
Sure.
Yeah. Thanks.
Any additional questions? Hearing none. Anything else, Mr. Bieber?
No, we have no further testimony.
Anything else from council on this case?
No, Mr. Examiner, thank you.
There's one. So just for the record, there is a request from Mr. Boer for the parties to submit a joint supplemental information for the record, and we'll. So how long do you think it'll take for the parties to supplement the record?
I don't think it'll take long on Lime Rock's part. I mean, with the caveat that assuming we can agree to sort of the price and any other, input parameters, I think potentially a week, but open.
Mr. Mayor, I'd suggest I'll run at $65 oil and $3 gas to level set with Lime Rock. I'm fine with that. Is any objection?
That'd be agreeable.
So how about if we just keep it open till July 10th, just to give everyone a little flexibility?
I think that's a good idea.
Okay.
Thank you, Mr. Examiner.
We'll keep the record open until the close of business on July 10th for the parties to submit a response with respect to Mr. Boer's request. Unless there is anything else, we will close the hearing on with respect to case numbers 32730, 32925, and 32926. And we'll take just a 5-minute break, go off the record. All right, we'll go back on the record. It is 10:32 a.m. Next case on the docket is case number 32833. This is a continued application of Oasis Petroleum North America LLC for an order amending the applicable orders for the Black Slough and/or Foothills Bakken pools in Burke County, North Dakota to one, establish an overlapping stand-up 1920 acre spacing unit described as section 6, 7, 18, and 19, Township 161 North, Range 92 West, and authorize 3 horizontal wells to be drilled on such unit. 2, establish 2 overlapping laydown 1920 acre spacing units described as sections 28, 29, and 30, and sections 31, 32, and 33 in Township 161 North, Range 92 West, and authorize 3 horizontal wells to be drilled on each such unit. 3, establish 2 overlapping stand-up 2560 acre spacing units described as sections 4, 9, 16, and 21, and sections 5, 8, 17, and 20 in Township 161 North, Range 92 West, and authorize 3 horizontal wells to be drilled on each such unit, or 4, granting such other relief as may be appropriate. Mr. Mann, this is your case.
Yeah, thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Oasis Petroleum North America, LLC. Mr. Examiner, I've got 2 witnesses in this case. It'll be Taylor Roberts and Tyler Smith.
Okay, so Mr. Robert, will Mr. Roberts be your first witness?
He will.
Okay, raise your right hand, please. You solemnly swear, just give me 1 second. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes, sir.
Thank you.
Taylor, can I have you state your name for the record?
Taylor Roberts.
And then go ahead and tell us by whom you're employed, what capacity, and include your business address.
Sure. Senior staff landman at Cord Energy Corporation. Business address 1001 Fannin Street, Suite 1500, Houston, Texas 77002.
And Taylor, have you previously testified before this commission?
Yes, sir.
And have you had your qualifications received as that of an expert?
Yes, sir.
Are you familiar with the land matters associated with each of the requested spacing units you're requesting today?
Yes, sir.
Okay. I have no further questions. Excuse me. I would actually like to offer the testimony of Mr. Roberts as that of an expert.
Any objections?
No objections.
Your offer is accepted.
And I'm going to have questions for Mr. Roberts. Taylor, let's start with L1. There's a number of spacing units you're requesting as part of this case. Can you just go ahead and identify those?
Sure. Exhibit 01's original locator map of Township 161 North, 92 West. We'll start south to north. Not requested laydown 1920 being sections 31 through 33 in the green box. Purple box being sections 28 through 30. Laydown 1920 and going west to east. Stand up 1920 being sections 7, 18, and 19 in the blue box. Stand up 2560 being sections 5, 8, 17, and 20 in the black box. And finally the orange box being sections 4, 9, 16, 21 being another stand up 2560.
Okay. Let's go ahead and take a look at L2. What's your working interest in those spacing units?
Sure. See the table below, but we'll discuss each unit. The laydown 1920 being sections 31, 33 of the green box, 70.55% working interest. Purple box being sections 28 through 30, 70.72% working interest. The orange box being sections 4, 9, 16, 21, 41.75% working interest. Black box being sections 5, 8, 17, 20, 71.1% working interest. Blue box, sections 7, 18, 19, 78.08% working interest.
Okay. And then Taylor, on L3, I don't think I need you to go through and read each one of them, but is this a breakdown of the underlying spacing units and the working interests in those?
Yes, sir.
And Taylor, have you reached out and received any support from any other working interest owners for these proposed spacing units?
Yes, sir. I believe we have 4 in hand.
And I think we have those identified in exhibits. L4 would be one of them. Do you have any information with respect to Posse and their interest and support?
Sure. Posse owns a 0.0977% working interest across 4, 9, 16, 21. Mr. Sawyer owns the sections in 17, 20, immaterial interest. Mr. Kenneth Stevenson owns 0.0098% working interest across 4, 9, 16.
21. And William R. Everett owns 0.38% working interest across 4916. I'm sorry, in 1621, but also owns an interest in sections 5 and 8, 17 and 20, 28 and 33, and 29 and 32. Okay, those are all the letters of support.
And that covers the letters of support that are contained in L4 through L7. Taylor, has Oasis been communicating with Phoenix with respect to the spacing and sort of operations in this general area?
Correct.
Okay. And as part of those negotiations, Oasis has, made some concessions with respect to some things that Phoenix wanted and vice versa.
Correct.
Okay. And is it your understanding that Phoenix had indicated that they were okay with Oasis at a minimum, including Section 9 as part of their spacing and development?
That is correct.
Okay. What do you base that understanding on?
Sure. Emails, I believe.
In the record, we've got an email chain with representatives of Phoenix and Oasis. Is there something within that email chain that would indicate that your understanding of that Phoenix supports Section 9 being part of what Oasis would operate?
Correct. Yeah. Going back from January all the way to late February, emails were exchanged between Mr. Arndt and leadership at Cord regarding the spacing in this area and other spacings, and in order to avoid as many protested cases as possible, we worked together to try and find a solution that doesn't bring us to these Friday cases. We were able to make agreements on some more Cord gate concessions, including Section 6 here. We originally had this space as 4, 5, 6, 7, 8, 9 laydowns. Phoenix expressed their dislike to that spacing, given their ownership in 6. And like I said, concessions were made on both sides. We removed our spacing of 6. We offered to respace this, trying to stay within our footprint. And as part of that agreement, both Cord and Phoenix agreed to allow Cord to space Section 9 within its operated footprint. Obviously, 4 was not anything that was agreed upon between Cord and Phoenix. 4 was not spaced. It is spaced as a 1280. We've reached out as recent as Tuesday to say, we see this agreement as is via this email back and forth, willing to work within the agreement that we made between the two parties, and we're told that they don't see it the same way.
Sure. And would including Sections 4 and 9 as part of your proposed development, that would keep sort of a uniform, orderly, kind of plan of development within the township?
That's how we see it. And then we have another formal spacing coming up for Sections 23, 26, 35, and that would complete the spacing for this township.
And it would allow for the longer laterals of the 4-mile development.
Yes, sir.
Sure. I have no further questions for Mr. Roberts at this time. I'd offer the land exhibits.
Any objections to the offer for the exhibits?
Well, to the extent these purported letters of support I don't see where any of these letters of support state that they are an owner within Cord's requested spacing. And so I'm just questioning the relevance of any of them at this time.
Okay, so you're objecting. What you're saying is, are you raising an objection to L4, 5, 6, and 7?
As currently presented, yes.
Okay, do you have any other objections?
No further objections to the exhibits.
Okay, the exhibits will be admitted over objection, and your objection will be noted for the record, and the exhibits will be considered based upon the information that's provided in the within the exhibits,
Sure.
given the appropriate weight. Do you have any questions for this witness?
Sure. Taylor, you talked about Oasis presenting this application based on a purported agreement with Phoenix and Phoenix acquiescence to Oasis's spacing, correct?
Correct.
And do you happen to know when this application was filed with the commission?
It's been continued a couple months, I believe. Maybe it was filed in, I believe, March.
Okay.
I could be wrong.
I'm going to hand you. Do we have another copy of this? Sure. Yeah, can we get another copy? Just one moment. So after this email exchange in February, are you aware of any subsequent conversations that Phoenix had with Cord with relation to the spacing?
Yes.
And what is your understanding of those conversations?
I've had a few conversations with their business development.
Would that be with Blair Brummel?
That is correct.
Okay, I'm going to hand you what will be listed on Phoenix exhibits. There you go.
Get a copy for Taylor.
Yeah, I do. Okay. Yeah, there you go. Thank you. So I'm handing you an email exchange. If you look at the top, you notice this is an email from Justin Arnn to Jason Weddle and a few other folks at Cord in Phoenix, correct?
It looks that way.
And looking down at the highlighted portion, can you read that highlighted portion for me?
Per the email from Mr. Arnn on March 19th. Additionally, we see that case 32663 remains on the docket. Phoenix intends to protest this case as well, given our majority interest in your proposed 4-mile unit, being sections 3, 4, 5, 6 of 161 North, 92 West, where Phoenix owns fully 69%. Additionally, Phoenix owns 70% of the working interest in section 9. Our development plans in this area have changed significantly, and we can't support your operatorship of a 7, 8, 9 laydown either.
And then can you read that last sentence of that paragraph?
The non-highlighted.
Please, thank you.
We see 4.9 as better suited in a different configuration that does not include an already producing cord well, along with the depletion of the company's end.
Have you seen this email exchange previous?
No, sir.
To your knowledge, was this shared with Mr. Mann?
Not to my knowledge.
So clearly within the email exchange, Justin Arnn is objecting to Cord's use of both sections 4 and 9, correct?
In this copy that you provided, yes. In the email that I provided, it said that they were okay with the spacing 9.
But if you read the top of this email, what's the date there? It's March 19th, 2026, correct?
Yes, sir.
And the email that you provided, Mr. Mann, for preparation for this hearing, where Phoenix purportedly agrees, is February 20, 2026?
Correct. Your email appears to be dated after the email that I'm providing. Correct.
Okay, I want to, Taylor, just have you take a look with me at exhibit, just so we're looking at the same one. Go back to exhibit L1 with me, please, if you would. So on exhibit L1, we're showing Oasis's proposed 4, 9, 16, and 21 4-mile spacing unit, correct?
Yes, sir.
And is there existing production in 16 and 21, correct?
Yes, sir.
And have you looked at the existing, how much that well has produced?
Not recently, no, sir.
And that's an Oasis well, correct?
I believe so.
And I guess would it surprise you that as the NDIC records reflect that there's been, as of April of this year, 199,000 barrels of oil been produced from the Kukuk well. I believe that is the Kukuk well in 16 to 21.
Would that surprise me?
Yes.
If that's what you say, the NDIC website says, I'll believe you. Yes, sir.
Yeah. And so in creating a spacing unit that includes 4, 9, 16, and 21, you're combining producing acreage with non-producing acreage, correct?
Appears that way, yes, sir.
And the owners in 4 and 9 haven't gotten the benefit of production from that well in 16 to 21, correct?
That is correct.
And the owners in 4 and 9 won't be getting the benefit of production from that well in 16 to 21 on a go-forward basis, correct?
The well in 1621 is spaced to section 16 and 21.
Right, so they won't be getting any production from that well on a go-forward basis.
Correct.
Okay. And so I know that your engineering witness will cover this, but do you happen to know how many wells that Oasis intends to drill? 3 additional wells, is that correct?
I believe Tyler will speak to that, and is this located on exhibit E1.
Right, so there'll be ultimately 4 different well bores in section 16 to 21. Is that correct?
Like I said, Tyler will speak to the development plan on 1621.
Let's see. Oasis's leases in section 1621, those are all held by production, correct?
Correct.
But the leases in 4 and 9 are not held by production.
I believe they are.
The leases in 4 and 9?
I believe they're held by other production. Yes, sir.
Would surprise to know you that they're not held by other production?
No, sir.
So if you didn't drill the wells in this drilling and spacing unit within the primary terms of the leases in 4 and 9 that are not held by production, those would ultimately expire, correct?
I think, yeah, that's kind of a general land 101, right? If any leases don't have production,
sure,
they'll lapse and terminate.
Sure. So we have this configuration, but I mean, just generally in those emails, there's another, or at least one other, if not several other different configurations Cord was considering, correct?
Correct. Yep. And that's kind of, I guess, where we were back in February and March when we were working with Phoenix on the best way to space this and not get out of each other's hair.
Sure.
And I think that's where we struck on the agreement via the emails that I provided.
The purported agreement.
Right. Where both parties stated that they were in agreement to that. So I can't speak to.
So is there any other way to space this acreage?
Sure. Yeah. And we even reached out to Phoenix, I believe as late as Tuesday and the week or 2 weeks prior to that, offering as to our agreement to space 9, 16, 21 as a stand-up 1920 and let Phoenix do what they wish for. And we were told that Phoenix did not respect or see the agreement that the two parties had agreed to in the emails that I provided.
But you hadn't seen the interim email where Mr. Arn articulates that they're not okay with Oasis spacing over 4 and
9. As a follow-up, no. And I can't confirm that we've seen this as well at this time.
Right. Okay. So just as another follow-up, there's ways to space this acreage that don't include 4 and 9, correct? There's other spacing configurations that don't include Phoenix's 2 mile.
Sure. Like we originally planned to space it as 4, 5, 6, 7, 8, 9, and we were told it was not attractive to Phoenix, so we tried another approach, and here we are trying to work with the parties that be.
Right, and there is another approach to this Oasis's plan that wouldn't have to include 4 and 9, correct?
I'm sure we could redraw spacings multiple ways. Yes, sir. Do you happen to know whether Phoenix submit permits on 4 and 9? I heard y'all say in a separate testimony on Wednesday that y'all have submitted permits in this unit, but I don't believe it's public knowledge of whether or not other companies submit permits to the state.
Are you aware if 4 and 9 have previously been spaced as a 1,280 acre spacing unit?
Yes, sir. I'm aware of that.
No further questions.
Do you intend to submit any exhibits into the record?
Yeah, we have had Mr. Mann and Mr. Roberts. Is that correct?
That's awesome. Sir.
Yeah, Mr. Roberts review the email, but we intend to offer it as an exhibit to our own application.
So not at this time.
Not at this time. Thank you.
Any redirect?
No, Mr. Examiner. Thank you.
Any questions from staff?
Taylor on exhibit L4, L5, L6, and L7. As opposing counsel pointed out, these letters don't contain any information that says that they're relevant to this case.
Sure.
So I would just point that out. On exhibit L8, what part of L8 are we to be focusing on?
You'll go to okay, page 7. I'm sorry, I have a different copy, but same copy. But just, yeah, page 7 where it says 16192 area, Cord North Wildwoods area.
Yeah.
That specifically, blue is what was agreed upon between the parties, and if you'll obviously you can't review this in its entirety right now, but you'll look at more recent emails where both parties, including Mr. Arnn and Cord leadership, agree that as to what was conceded between both parties, blue is what was agreed upon. Green was what Phoenix agreed to, and red was what Phoenix disagreed to. And so this is how we approach the area, given concessions we made with them to allow them to space other sections without protest.
Okay, thank you.
Yes, sir.
Any additional questions? All right, hearing no additional questions. Mr. Mann, you may call your next witness.
Tyler Smith.
Mr. Smith, could you raise your right hand, please? Sir. Do you solemnly swear or affirm under the penalties of perjury that the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief? Yes, sir. Okay.
Tyler, can I have you state your name for the record?
Yep, Tyler Smith.
And go ahead and tell us by whom you're employed in what capacity and include your business address.
I'm a senior development engineer for Cord Energy, who is a parent company of Oasis. Cord's headquarters are at 1001 Fannin Street, Suite 1500, Houston, Texas 77002.
And Tyler, have you previously testified before the commission?
Yes, sir.
Have you had your qualifications received as that of an expert?
Yes, sir.
Are you familiar with the engineering matters associated with the requested spacing units?
Yes, sir.
Okay, I'd move the testimony of Mr. Smith be received as that of an expert.
Any objection?
No objection.
Motion's granted.
Tyler, let's start first with a little bit of geology in G1. Just walk us through the structure underlying these spacing units.
Yep, so G1 shows the Upper Bakken structure map for the proposed area. The map is in 25-foot intervals, dipping to the southwest, top being 5750, bottom being 6200. And you can see the type log used there, seen in section 31.
Okay. And then moving on to G2, you've got an isopack. Just describe what that's depicting.
Yep. So G2 shows the middle Bakken thickness map for the proposed area. Again, thickening to the northwest in 2-foot intervals, with the area of interest having an average thickness of around 50 feet.
Okay. And then you've identified a type log, and that's on G3. What are you showing on the type log?
Yeah, so G3 shows a representative type log, also known as a triple combo log, for the geologic parameters that were all the reservoir were built off of.
Okay. Let's move on then to E1. We've got a number of proposed spacing units we're discussing. Just walk us through how you intend to develop each of those.
Yep. So E1 shows kind of your Oasis plans to develop this area. Two 2560 DSUs consisting of 3 new 4-mile stand-up wells being drilled from north to south. Those are seen in sections 4, 9, 16, 21, and then 5, 8, 17, and 20. One 1920 DSU consisting of 3 new Bakken wells being drilled from north to south. That can be seen in 7, 18, 19. And then 2 1920 DSUs of 3 new Bakken wells being drilled from east to west. Those laydowns on the bottom seen there, the 2 DSUs on the bottom there.
Okay. Let's move on to E2 then. Just take us through the reservoir data and then what the economics would look like on each of the spacing.
Okay, so E2 displays the reservoir and economic properties on a per well basis for the planned development. The top table shows the reservoir properties used in the analysis. And then focusing your attention on the middle table, one can see the OOIP to be 9.2 million barrels per section, resulting in a well EUR of 405 MBO for the 3-mile wells and then 532 MBO for the 4-mile wells. The table on the bottom reflects the capital investment of 8.4 million for the 3-mile wells and 10.6 million for the 4-mile wells, with a rate of return of 30 and 34%, respectively.
Okay. And Tyler, are the economics of 4-mile development in this particular area typically better than 2-mile development?
Yes.
Okay. And in the previous case, we heard some Phoenix Engineering testimony that generally 4-mile development's better than 2-mile. Would you agree with that general statement?
Yes, I would.
Okay. In your opinion, would establishment of each of these spacing units with the development that you've described, is that going to prevent waste, protect relevant rights, prevent the drilling of unnecessary wells?
Yes, sir.
Okay. I have no further questions at this time. I'd offer the geoengineering and gas capture plan affidavit. Exhibits.
Any objections?
No objection to admission of the exhibits.
Exhibits are admitted. Any cross-examination?
Yes. Good morning, Mr. Smith. So I want to take a look at obviously sections 4, 9, 16, and 21. As Mr. Roberts stated, we're combining producing with non-producing acreage there, correct?
Yes, sir.
And there is a producing well, 16 and 21.
Yes, sir.
Yeah. And are you aware that has produced almost probably at this point over 200,000 barrels of oil?
Yes, I
am. Oasis doesn't have any plans to allocate production from that well for the benefit of the owners in 4 and 9, correct?
I don't know the answer to that, but Taylor, do you have?
But up until this point, they haven't gotten the benefit of that.
Correct.
Right. And so unless Oasis goes out of its way to allocate production from that well, their owners in 4 and 9 are not going to get the benefit of that well. Correct?
Yes, sir.
So Oasis's plans generally are set up to maximize production of the resource, correct?
Yes.
And also in this instance with the 4-mile DSU 4, 9, 16, and 21.
Yep.
So the amount of wells in 16 and 21 are what's necessary to fully drain 16 and 21?
Yes.
And there are a total of 4 separate wells that traverse 16 and 21, correct?
Correct.
And just to the north of 16 and 21, there's only 3 wells that traverse sections 4 and 9 in your plan, correct?
Yes, sir.
So wouldn't it be fair to say that if 4 wells are required to fully develop a resource, in 16 and 21, it'd be much better to have 4 wells to fully develop the resource in 4 and 9. Isn't that correct?
Most of the time, yes.
Yeah. And I notice also that it seems like the rest of these DSUs, whether they're your 3 mile or 4 mile, essentially they follow the same pattern, that there is an existing well within each section, but then an additional 3, right?
Yes, sir.
So sections 4 and 9 would be the only exception there, only having 3 well bores.
Yes, sir.
And I'll just follow up with you as well as I did with Mr. Roberts. Oasis had considered many different spacings in this area, correct?
Yes.
And in fact, there are other ways to space this configuration so as to exclude 4 and 9, correct?
Yes.
No further questions for Mr. Smith.
Any redirect?
No, Mr. Examiner, thank you.
Any questions from staff?
If 4 and 9 were not included, how would Cord develop the other 2 sections?
Most likely we would do 1621 as a 1280 and do what we consider hairpins from that existing pad, considering that we would be able to expand that pad and fit more wells on 16 and 21.
Okay. Do you guys, I didn't see it, but do you guys know what Phoenix's percentage in 4 and 9 is? Maybe this is a question for the land witness.
I'm not, yeah, sorry.
Yeah, don't have their title specifically, but aware that they've done leasing in 29, with leasehold expiring, most of it in 29.
2029.
Yes, sir.
2029. But Cord's interest in 4 and 9 is 7.5%.
That is correct. Yes, sir.
Okay. Thank you.
Any additional questions?
Tyler, on your exhibit E1, a large portion of the basin has been developed in a 1280 meter spacing unit. Is that correct?
Yes, sir.
And going to 3 and 4 mile wells to best protect the correlative rights of all owners throughout the basin. Virgin sections are going to have to be spaced into producing sections, aren't they?
Yes, sir.
I mean, it's going to happen. Okay, thank you.
Where were the pad locations anticipated to be in all of these spacing units?
So you can see those on E1 as the gray box highlight with the black border on there.
Sorry, maybe let me get there.
That's okay.
Got to sort through the email chain. So 4 and 9 were not included. Where would the pad location be for 16 and 21?
If we develop 4, 9, 6, and 21 together, it would be that pad shown on the north end of 4. If we develop 16 and 21, we have not looked into that directly, but most likely we would look at using that existing pad on the south end of 21 where that parent well is coming off of. Considering the fact that we would, like mentioned, be able to expand that and fit additional wells on that pad location.
Are your economics between your hairpin wells, 4 mile laterals, similar to a straight 4 mile lateral well? What's the correlation between a 4 mile straight well and a 4 mile U well, 2 and 2?
So the economics are very similar. The capex for a hairpin is a little bit higher just because you lose efficiency and synergies on frac. Cord usually likes to use simul-frac as our method of choice. When we only have 2 hairpin wells, we lose that efficiency. So that's why you see the CapEx go up a little bit. From a EUR perspective, we treat them the same.
Good. Thanks.
Yep.
All right, hearing no further questions. Anything else, Mr. Mann, for your witnesses?
No, Mr. Examiner, thank you.
Mr. Examiner, if I may, I beg your pardon, but I forgot to ask a question, or at least I didn't hear it elicited in the testimony. Mr. Smith, when does court intend on developing the DSU that is comprised of 4, 9, 16, and 21?
So these are currently on our kind of 3 to 5 year development plan, with the caveat that we are doing a delineation test in the nearby area, and pending results of that, this has the possibility to actually accelerate on our schedule.
Sure. Okay. But it's possible that Oasis doesn't get around to this till 3 to 5 years from now.
That is possible.
Okay. No further questions.
Anything else, Mr. Mann?
No, Mr. Examiner, thank you.
All right, Mr. Bieber, do you want to call? Do you have any witnesses regarding this case?
Yes, Mr. Examiner. We'll have our 3 witnesses. This is inclusive of the power direct. Sorry, we didn't use this, but this is going to be L6.
I think that's what he ended up doing. Yep.
Okay, Mr. Bieber, I see you've got Mr. Lewis and Mr. Shivy and Mr. Arn back in the saddle, and just remind the witnesses that they continue to be under oath. You may call your first witness.
First witness, Justin Arn. Justin, are you personally familiar with the land matters that are associated with Phoenix's, or pardon me, Oasis's application 32833?
Yes, I am.
And the exhibits that Phoenix had prepared for this hearing, did you prepare a cause to be prepared these exhibits?
Yes, I did.
All right. Can you just turn with me and just briefly go over L1 there?
Certainly. Exhibit L1 shows the regional map identifying the area of Phoenix's interest specifically sections 4 and 9 of Township 161 North, Range 92 West. We'll note that this section 4 and 9 was already spaced and is currently in a 2-mile, 1,280 acre configuration with, I think, 10 well bores approved in an order from 2015, as I recall, by an application from Oasis at the time.
And just Phoenix has recently submitted permits for the spacing.
Yeah, and Phoenix, just so that the commission is aware, Phoenix has recently submitted 2 permits on this spacing, 2 essentially switchback permits, essentially 4-mile laterals over the 2-mile stand-up configuration. Those were submitted, I think, to the NDIC on June 16th of this year.
And can you please describe L2A for us?
Sure. As per Phoenix's usual exhibits, L2A identifies the 1,280.32 acre spacing unit comprising sections 4 and 9. You'll see that Cook well just below with sections 16 and 21. Yeah, so that's just a zoomed in version identifying the wells that are currently producing in the area.
And L2B?
L2B is our proposed development plan for the area. The commission over the last few days has seen this development plan every day related to different cases that we have on the docket. Those cases to the north in 162 North, Range 92 West, mostly that the commission saw on Wednesday. This final piece relates specifically to case 32743, Phoenix's sidekick unit, that we also plan on developing from the same pad, actually, as this unit here, 4 and 9. Our goal with this development pattern was to try to keep development in a row, in a line, as best we possibly could. You can see we diverted just a little bit there in section 10 to accommodate the 5-miler that Phoenix wants to do. But our goal was to keep, when we were developing this area, including sections 4 and 9, was to try to keep surface disturbance and pad locations in the same area to support infrastructure.
Taking a look at Exhibit L3.
Identifying any state or federal leased or unleased interest. There's no, Phoenix shows no state interest nor any federal interest in the 1,280 acre spacing unit. So nothing to stop Phoenix from drilling this at this current time.
And L4.
L4 shows Phoenix's working interest in the proposed unit being just under 90%. And I'm sorry, I keep calling it a proposed unit. It's not a proposed unit. It's an already established 1,280 acre spacing unit in our proposed development plan, is what I should be saying. Phoenix owns just under 90% of the working interest. I heard in prior testimony that court is claiming 7.5% of the working interest. That's very possible. You can see that we're seeing 3.12% working interest owners and some unleased owners out there. It's possible that court took some or Oasis took some recent leases that we're just not aware of. So something true.
And you heard discussion around different spacing configurations that would avoid inclusion of 4 and 9. Taking a look at Exhibit 5, can you explain one possible alternative that would maximize some efficiencies there?
Certainly. I think that from our perspective, with regards to court's development plan, and I've said this, I think, in earlier testimony, not trying to mix depleted acreage with already producing acreage is the goal. It's not always achievable. Is it achievable in this particular area? It certainly appears so to Phoenix. I'm just going to identify a very quick configuration that I think court could consider. Definitely not optimal. I don't work for court. But you could certainly develop a 4-miler using sections 16, 21, 28, and 33. You could develop 2 3-milers from a common pad, 5, 8, and 17, along with 20, 29, and 32. And then you could develop their hairpin, like they like to describe, 7 and 18, and then 19, 30, and 31, again from a common pad, I just described a configuration that court could potentially do using 3 pads, developing a 4-miler, 3 3-milers, and a 2-miler pretty easily without incorporating sections 4 and 9, where court owns very little working interest in. I'm pointing this out just to say that, yeah, there are other configurations that could absolutely be done to not include that non-depleted acreage in the unit. That's not necessarily what we recommend court do, but it's a consideration.
Okay, and Justin, I want to point your attention to what we're going to mark as Exhibit L6. We weren't sure if we needed this, but nonetheless, we have what's marked as Exhibit L6, or not marked, but we are going to mark as Exhibit L6. Do you recognize what's on the first page there?
I do.
And what is that we're looking at?
We're looking at a response from myself to Jason Weddle and certain members of court. I'll note that Taylor Roberts wasn't actually on this email thread where I responded to Jason. Court has had a number of configurations in this area. I'm sure the board has seen by way of different applications over the course of the last 6 to 7 months. The very first set of configurations I think we thought was the most egregious with regards to Phoenix's acreage. And so, one of the things that I think I want to point out with regards to the board is when you look through some of these email threads, is the extraordinary communication that happens between operators. I don't think we usually get to see this in these exhibits. I don't necessarily know why court thought that this one was a good one to bring up as an idea of us reneging, if you will, on a deal. But in fact, court is here trying to space 2 sections that they own minimal working interest in when they don't have to. They absolutely don't. They could configure in a different way, as we discussed. And Phoenix at no point ever agreed to allow sections 4 and 9 to be spaced in the configuration as you heard today from court.
Well, and just to follow up on that point, in this exhibit, what we're going to call L6, if you turn with me to page 8, which I believe, just so we're, because I know there's a lot of pages here, I want to identify what that is. Also on Cord's exhibit, I believe on Cord's exhibit, the same text appears on page 7 of their exhibit L8. Okay. So there's a paragraph towards the bottom there that's highlighted in yellow. The text highlighted in yellow, or I guess, can you just walk through us or just walk through for us the contents of that paragraph along with what's highlighted there?
What page?
Pardon me, Wade. It's page 7 of Cord's exhibit, page 8 of.
Okay.
Yeah, it's the same paragraph.
I think it'd be easier for me to just walk through that whole paragraph.
Right.
I'll try to do it quickly.
Yes, please.
Just so that we understand the context here. What we're talking about is bullet point 3 on 161 North or 16192 Cord, Wildwood North, Wildwoods area. So about 2/3 way down the page, bullet point number 3. The writing there in black is Cord's writing, attempting to get Phoenix to agree to a certain configuration. The cording, or the everything in colored there, is essentially my writing. So Phoenix agrees to Cord spacing and operating without protest from Phoenix sections 3, 4, 5 as a DSU, along with currently proposed 7, 8 boundary. This was back in, I think, January of 2026 when they had a completely different configuration than what you guys are hearing here today, 6 months later. My response, 7, 8, 9 is fine, 3, 4, 5 is not. Phoenix owns more than Cord in this proposed 3, 4, 5 laydown and over 50% as a whole. I recommend Cord rethink its strategy in the northern part of this township. Furthermore, Phoenix agrees not to space over top of Cord's producing units in this area. You'll notice that we haven't done that in any of our spacing configurations, in one that you've heard this week or prior. Incidentally, Phoenix has no plans to space over top of Cord's producing acreage in any area in the Bakken. and we still don't with regards to Cord at this time.
And just to point out, I mean, 4 and 9 was spaced actually well in advance of these email exchanges, correct?
Correct.
By Oasis, as far as you know, correct?
By Oasis.
All right, turning now, setting aside Exhibit L6, Justin, just taking a look at Exhibit. Oh, I guess we don't have one. No further questions for Mr. Arnn, and move for admission of the land exhibits.
Any objection to exhibits, counsel?
No objection.
Exhibits are admitted. Any cross of this witness?
Yeah, Mr. Arnn. So Unit Gate 4 and 9 was previously spaced as a 1280.
That's right.
And but in February, you really had zero concern with having Section 9 be included as a laydown, including Section 7, 8, and 9, correct?
I wouldn't say I had no concern. I think my response is 7, 8, 9 is fine.
Yes, correct. Let's look at Exhibit L2B.
Mm-hmm.
I think you got it shaded in, I don't know, it's like tan, that Willow unit.
Correct.
And Court was initially opposed to you including Section 6. Is that correct?
We were opposed to Court's 4, 5, 6 laydown, I think is a better framing of that.
Well, I think if you look at the bullet points, I think it says in there that Court agrees to Phoenix spacing 162.90, 161.92, 6 as it sees fit without protest from Court.
Well, that was a response to a 4, 5, 6 laydown that was already on the docket from Court. So
at one point in time, Court objected to having 6 included in that stand-up 2560, correct?
I don't think that that's the right framing. In fact, I don't think that you're aware of the timeline is all I'm saying. In fact, 4, 5, 6 was set up, I believe, by Court as a laydown that Phoenix protested and gave the reasons why. And then Phoenix told Court exactly how we planned to configure, and they supported. So at no point did Phoenix protest or disagree with our Willa unit. I think your framing of it is just a little incorrect.
I disagree. I think, and the commission can read the email and
Sure.
bullet points in page 8, but it's apparent from that Court at one point did object to your Section 6 being included as that unit, part of that unit.
I'd have to read through it right now. We can read through it right now if you want. We can try to walk through exactly what this was from 6 months ago if you'd like.
I don't think we need to get bogged down in that, but like I said, there is that bullet point where, as part of this arrangement or agreement, Court agrees that Phoenix spacing Section 6 as it sees fit without protest. So
okay, I suppose also as part of that agreement, Court wasn't going to space Section 4 either. I think that
correct. I agree.
Okay,
but you also said then that 7, 8, and 9 as a laydown was fine.
Are we hearing 7, 8, 9 as a laydown today, or
no? We're not.
Okay, I'm failing.
But do you disagree that you said that?
I guess I'm going to have to object. It sounds like we're getting into discussion of whether a contract was formed, and I'm not aware that the commission adjudicates contract rights here.
Do you have a response, Mr. Mann?
No, the point is that as part of like an agreement or arrangement, that Court wouldn't protest 6. Phoenix indicated that they were okay with a configuration that that Oasis could space 9. They were fine with that. It says,
and that we're not hearing this morning either.
I understand that.
Yeah.
I guess I'll sustain the objection, the testimony, and the questions that are getting a little argumentative. So let's try to reduce the.
Understood.
Okay.
And I'm sure Oasis appreciates your input on how they can potentially develop their own acreage in L5. But
I'm sure.
So looking at other possible ways to develop, if you look at your L2B, could section 4 be included with your acreage to the north and have another 5 mile, 3,200, consistent with what you've got right beside it on with section 3 and those spacing or sections to the north?
It could.
Okay. I have no further questions at this time.
Any redirect?
Just briefly, Justin and I don't think Mr. Mann or Oasis's witnesses were aware of the relevant emails and subsequent communication and between the parties here, but just walk through it for us briefly on page 1 of L6. In that highlighted portion, what are you communicating there to Mr. Weddle at court along with other court personnel?
What we're communicating here is that as we go to our development plans in the area have changed significantly. And I'm reading again from a highlighted area, and we can't support your operatorship of a 7, 8, 9 laydown either. We see 4 and 9 better suited in a different configuration that does not include an already producing cord. I think it speaks for itself. Right. I think it's already been read. I think that I'm not sure that there's any. Is there any questions about what I'm communicating?
No.
Okay.
And let's see here. No further questions.
Anything else, Mr. Mann?
No, Mr. Examiner, thank you.
Any questions from staff?
Justin, I guess just real quick.
Yes.
Do you know what Phoenix's percentage would end up being of the proposed 2560 of 4, 9, 16, and 21?
I guess it would be about 45%, I think, roughly. I mean, given we have 90% of the 1280, so about 45% of the 2560. I think that's accurate. Phoenix doesn't own any interest in section 16 or section 21.
Okay, thank you.
Thank you.
Justin, it's been brought up in this case, that you don't want to include acreage that already produced into a 4-mile spacing unit. That appears to be very inconsistent with the testimony we heard in the previous case, where Phoenix wants a space over wells that are currently producing. Can you explain the difference to me?
Yes. I think, and I hope I was clear in the last case that we don't want to do that where it's unnecessary. And we feel in that last case, in either configuration from Lime Rock or Phoenix, that there was virtually zero chance to develop those 3 sections. Certainly we could have developed 2 of them, but not all 3 sections without combining depleted acreage with producing acreage. And I think you made that point earlier today in your testimony or in your questioning of the court witness. We agree that there's absolutely no way around with producing acreage in this basin that you're not going to mix virgin acreage with producing acreage. That is a fact. It's going to continue to happen, and it's going to need to happen in order to fully develop this basin. That being said, in the instances where you don't have to, where you have 2 operators that are fully capable of developing their acreage that they have majorities in for the most part, without having to combine that acreage, that we believe the board should consider that alternative as the better one. In that prior case, I don't see any way around it. In this case, I do. And I think I've outlined at least a methodology where that might be able to happen.
Okay. On your exhibit L6, you have the highlighted portion of that paragraph.
Yes, sir.
And what about the paragraph right below that? It says, we are also not fans of case 32665, which would strand Phoenix a majority interest in 2 and 11 16193 into a 2-mile configuration.
Correct.
So how's that? So over there, you don't want to strand 2 sections, and here, I'll use that word loosely. You do want to strand 2 sections that develop it as a 12E. What's the difference?
So, and this is the tough thing about going into some of these old emails and negotiations. One of the things that I want to note, by the way, on case 32665, and I'm sure the board won't remember, but that was a case, in fact, where that spacing went through, and you probably don't remember, but I actually came up here to support Chord's configuration, which technically did put our acreage 2 and 11 into a 2-mile configuration. The board asked if they had reached out to Phoenix for support. Chord didn't have any ready response, but I happened to be here at the time. I came up and supported Chord's configuration, so they didn't have to reach back out to me for that to happen. So why did we do that based on this email here? The truth is 2 reasons. One of them has to do with potentially a different trade deal, which frankly, it's hard to even talk about because of CA agreements that doesn't have anything to do with Chord. But that's the difficulty of going into emails like this and trying to suss out reasoning. Furthermore, with Phoenix's understanding with regards to switchback or U-turn wells, at this point, we also think it's possible to develop 2 and 11, potentially economically and maybe even more economically than we have in the past. There's a myriad of reasons why we weren't necessarily for it in that instance, but then later, in fact, during the actual hearing, came back and supported. So I just want to point that out as a difficult thing when we're going back into these.
Yeah, I appreciate the explanation because just reading out of the surface, it seems very inconsistent.
Well, I would just say if anyone just comes in and tries to create a strand, what we thought stranded to a 2-miler without discussion, and there was further discussion after this, hence the reason I came up here and supported Chord's case. Yeah, that's generally going to be our response is we're going to defend our acreage where we can.
Okay, thank you.
Thank you.
Any additional questions? Hearing no additional questions, anything else for this witness, Mr. Bieber?
Nothing further, Mr. Examiner.
All right, you may call your next witness.
Next witness is Mr. Topher Lewis. Topher, are you personally familiar with the geology matters underlying sections 4 and 9?
Yes, I am.
And did you prepare cause to be prepared the geology exhibits for Phoenix's protest of 32833?
Yes, I did.
Okay, Topher, can you just walk through exhibit G1 for us?
Yeah, G1 structure map on the Upper Bakken Shale, subsurface TVD 20 feet. In this area, the structure is dipping to the southwest. The red outline is our proposed 1280 acre spacing unit, and the gold line is a 2-well cross section highlighting the type well that we'll reference in the next exhibits.
Take a look at that next exhibit, G2.
G2, upper portion is that 2-well cross section, plotting curves from triple combo, gamma ray resistivity, porosity. Black lines represent our generalized stratigraphy in the area, and they illustrate that the Bakken is present in the subsurface. And again, our target in this area would be the middle Bakken. The type well that we're using here is the Rebney 11-7H, and the table in the bottom, the petrophysical data from that well that we'll use in the next exhibits.
And is the middle Bakken present continuous across Phoenix's existing 4 and 9 spacing?
Yes, it is.
No further questions for Mr. Lewis, and move for admission of the geology exhibits.
Any objection to the exhibits?
No objection.
Exhibits are admitted. Any cross-examination of this witness?
No, Mr. Examiner.
Any questions from staff? All right, hearing no questions, Mr. Bieber, you'll call your next witness.
Our next witness is Mr. Eric Shibby. Eric, are you personally familiar with the engineering matters that are the topic of Phoenix's spacing in sections 4 and 9 that we're discussing here, in this case 32833?
Yes, I am.
Did you prepare, cause to be prepared, the engineering exhibits for Phoenix's presentation here?
Yes, I have.
Can you walk through real briefly Exhibit E1 for us?
Yes, Exhibit E1 is our standard three-string wellbore design we use in the Williston Basin, 4.5-inch liner cemented in place and completed via plug and perf.
And E2?
E2 shows our proposed development plan. Here we have an identified pad location there in the northeast of Section 4. As Mr. Arnon heard some previous case this week, that would be a two-unit pad. We'd be drilling 4 4-milers north, and we plan what we call switchbacks, 2 switchbacks in sections 4 and 9. I will add that Phoenix has just recently, this month, drilled successfully their first 4-mile switchback in the state of Montana, and we're currently drilling our second switchback on the same pad there.
And excuse me, turning to E3.
Yes, E3 is our economics here. Start up at the top with the ARPS parameters. I'm showing about 650 MBO per well, and that would be a 4-mile lateral. And one thing I'd like to point out, so in sections 4 and 9, it's 650 times 2. I'm estimating 1,300 MBO per oil for that sections 4 and 9. I think I heard correctly that Oasis's type curve for a 4-miler was 532.
Right.
So if you do that math there, taking a 532 and dividing in half, and 4 and 9 are only getting 3 sticks, the recovery out of sections 4 and 9 would be around 800 MBO. So I am showing a higher type curve, yes, but also with that addition of 1 extra stick, we're recovering more oil. And then the economics below, again, I've run at $70 oil and $3.50 gas. About the DNC cost estimated at $11.76 million, yields a PV10 of $7.4 million per well, and internal rate of return of about 45%.
And Eric, there's an existing well in section 16 and 21, just below 4 and 9.
Yes, I believe. Yeah, you just mentioned that one, Aaron.
Right, and did you take a look at the production for that well?
I actually know. I was listening to your testimony. I believe it's around 200,000 barrels. Was it?
Yeah, the NDIC records reflect that.
Yeah.
So ultimately, 16 and 21 have already been depleted.
There's been, yes, the oil drain from those 2 sections, correct.
What are the concerns that 4 and 9 get included with 16 and 21 in terms of a 4-mile spacing unit that includes all 4 of those sections?
I think I addressed that, Aaron. It's the idea that with Phoenix's proposed development plan,
right,
sections 4 and 9 get the benefit of 4 sticks, if you will. And I think Chord's development plan, there'd only be 3 sticks going up into sections 4 and 9. I think that's how I quickly summarize it, if that answers your question.
Yeah, it does. No further questions for Mr. Shivy, and move for addition of the engineering exhibits.
Any objection on the exhibits?
No objection.
Exhibits are admitted. Any questions for this witness, Mr. Mann?
Yeah. Thank you, Mr. Examiner. Mr. Shivy, I believe you testified under oath in the last case that Phoenix prefers 4-mile laterals to 2-mile laterals.
Yes.
Okay. And in that case, sections 8 and 17 were virgin reservoir, if you recall. Is that correct?
In the previous case, Mr. Mayor?
Yes,
that's correct.
And Phoenix elected not to attempt to space 8 and 17 as a 1280, correct?
That's correct.
Okay. And instead, they attempted 2 2560s, one of them which spaced over 3 operated Lime Rock units, and another one spaced over 2 operated Lime Rock units, correct?
That's correct.
Okay. With respect to the switchbacks, I think you've drilled one. Have you completed that one in Montana?
No, we haven't. So we're still drilling the second well on that path.
Are there any risks in drilling U-turns?
It didn't appear so with our first one. I mean, there's always risk drilling wells, sure, but it actually went fairly smoothly for our first one.
So how about on the completions with respect to completing a switchback? Is there going to be some risk associated
There
with
will
that?
always be some risk, probably a little bit additional risk to be fair, but we haven't done our first completion on a switchback yet. But we don't intend any,
Okay. So would there, in your opinion, would there be less risk with drilling sort of a traditional straight 4 mile lateral?
Again, you could say there's a little bit minimal risk, but I don't think the switchback adds dramatic amount of risk. No.
Sure. I have no further questions.
Any redirect?
No, nothing further.
Any questions from staff?
Eric, how many wells are going to be drilled from that pad in the northeast of section 4?
Mr. Anderson, yes. Let me back up to that. That will be 4 wells going north. 4 4-milers will be going into our sidekick unit, and 2 switchbacks in this section 4 and 9, which we call our frosty unit. So a total of 6 4-milers basically would be drilled from this pad.
Good, thanks.
Sure.
Eric, on your exhibit E2, the western U-turn well,
Mhm.
I mean, I assume that's going to be connected to that pad via some kind of a drill back or something like that.
Correct. A tangent out to that point. Correct.
And then you have wells going north, obviously. So there'd be a little bit of additional anti-collision.
Correct. Back builds and everything to consider. Yes, sir.
Okay, thank you.
Any additional questions? All right, hearing no additional questions, anything else, council, in this case?
Nothing further, Mr. Examiner.
No, Mr. Examiner.
All right, with that, we'll close the hearing on case number 32833.
Jeez.
So the next case is going to be about the same length as this one?
I suspect not. We're only going to have one witness. Yeah, on our side anyhow.
Let's take a 5-minute break, and if it works into 10,
A 5-ish minute break.
All right, we're all back from our break. So go back on the record. It's 11:53 on Friday, June 26th. Last case on today's docket is case number 32737. This is an application of Whiting Oil and Gas Corp. For an order amending the applicable orders for the Mondack and/or Estes Bakken pools to establish two overlapping laydown 28 80-acre spacing units described as section 2, 3, 4, 5, and 6, Township 149 North, Range 104 West, and section 7, 8, 9, 10, and 11, Township 149 North, Range 104 West in McKenzie County, North Dakota, and authorize 4 horizontal wells to be drilled on each such unit or granting such other relief as may be appropriate. And I see that we have the same witnesses that have testified before this morning, so I'll just remind them they continue to be under oath. Mr. Mann.
All right, thank you, Mr. Examiner. So Taylor Roberts will be the first witness, and Taylor, let's start with L1. If you can just start by identifying the general area of these spacing units.
Sure. Exhibit 01, regional locator map, McKenzie County, North Dakota. Two 2880 acre spacing units being sections 2, 3, 4, 5, 6 of 149 North, 104 West. And the other one being sections 7 through 11, 149 North, 104 West, excuse me.
Sure. And then moving on to L2, with respect to each of those spacing units you've identified, what's your working interest in those?
Sure. The northern 2880 being sections 2 through 6, 53.12% working interest. The southern 2880 being the red box, sections 7 through 11, 47.33% working interest.
And Taylor, are there any other working interest owners with a fairly significant acreage in each of these?
Yes. The northern 2880 Kraken Operating LLC has a 27.68% working interest, and the southern 2880 Kraken has a 24.7% working interest.
And I think we've got an exhibit a little bit later, but is Kraken supported the spacing that you're requesting?
Correct. They have signed letter of support, testing to such.
Okay.
So with our interest and their interest in that northern 2880, that's 80.8%. In the southern 2880, that's 72.03% working interest.
Sure.
Somewhere together.
Sure. And then looking at L3, just a breakdown of the kind of existing underlying spacing.
Sure. Yep. There's the working ownership, working interest ownership of each section. 2 and 11, roughly 68%. 3 and 10, roughly 12.5%. 4 and 9, roughly 94%, just a little shy. 5 and 8, almost 47% working interest, and then Cord has no working interest in 6 and 7.
Sure. And then moving on to L4, just kind of walk us through sort of, I guess, some of the challenges with development in this area due to some of the federal interest.
Sure. There's a lot of unleased federal lands in this area. It takes some time to get that nominated, get the SMA reviewed and approved, and then on an upcoming lease sale.
Sure. And then L5, you sort of have a rough plan of potential spacing in the area?
Sure. Yes, sir. And there's, the green red box that we're testifying to today, and then some potential spacing units that we see could be as potential options to completely develop this and leave the acreage.
Sure.
Undeveloped.
And then Exhibit L6, as you alluded to, the Kraken is supporting your spacing and have indicated their working interest. Is that the letter of support?
That is correct. And I believe this one, unlike the ones maybe prior, state that they own in what sections.
Identifies what their working interest is in each of the two spacing units.
Correct.
Sure. I don't have any further questions for Mr. Roberts at this time. I'd offer the land exhibits.
Any objection?
No objection.
Exhibits are admitted. Any questions for this witness?
Yes, just a few. Taylor, I just wanted you to take a look with me back at your exhibit, L4. You guys compiled a summary of federal unleased acreage here that is both up for the 2026 July sale and then also nominated, correct?
Correct.
And don't both of these DSUs include federal minerals, undivided 100% federal mineral tracts?
Both just include federal minerals, yes, sir.
Right. So both DSUs ultimately you couldn't drill through until the pending the federal lease sale, correct?
In general, you can't. Oh, turn my mic on. Forgive me. In general, you can't penetrate on these federal lands.
And so what's been nominated there, the federal acreage that's depicted, that would prevent you or anybody really from drilling through those federal minerals until a lease sale is eventually completed, correct?
Correct. You can't penetrate on leased federal lands. Yes, sir.
So it'd be fair to say that we're at least a year, if not 18 months or more out from that date, given how long the BLM lease sales take.
Depending on what's on the January lease sale, but yeah, it could very well be that timeline. Yes, sir.
Sure. And so you don't really know for sure when you're going to be able to drill these units.
Correct. Yeah, anybody with unleased fed until that's nominated and leased doesn't really have any certainty as to when you'd be able to develop it. You're correct.
When you have your potential future spacing on L5 there, given the amount of unleased acreage in this area and ownership yet to be determined, aren't there a number of different configurations that this area in 149, 104, and 150, 104 could be spaced?
Yeah, we generally like to work with other operators. I know y'all spoken to that on Wednesday. I don't know if I heard it today, but on Wednesday, if y'all willing to work with other operators when spacing units, and we pride ourselves on trying the same tonight. Get to a Friday contested hearing.
Right. In 7, 8, 9, 10, and 11. And so, are you aware that there's over 44.4% of that proposed spacing is unleased fed acreage right now?
I know there's quite a bit of unleased fed, but not to the point of 44.
Okay. Are you aware more generally of unleased fed acreage in the area in 150, 104 north of your proposed basin?
Yes, sir.
And that there's a significant amount of unleased fed just to the north in 150, 104?
Yes, sir. Yeah, there's some coming on lease sale in 2833. Just to the north.
Do you have a beyond what you have in L5? Do you have a development plan for the broader area?
Not with us today. We try to look at obviously where we have interest and what makes sense for us and our peers in the basin.
Sure. No further questions for Mr. Roberts.
Any redirect?
Sure. Taylor, even with the unleased fed, what you're proposing it isn't really going to strand any acreage regardless of the outcome of those fed lease sales, is it?
We don't see it that way and trying to stay within that township boundary.
Okay. And again, with Kraken support on what you have spaced, you've got 80% and over 70% in those spacing units, correct?
That is correct.
So I have no further questions.
Any questions from staff? Right, hearing no questions, you may call your next witness.
Next witness is Tyler Smith. And Tyler, let's start with a bit of geology again, and on G1, just walk us through the structure underlying those requested spacing units.
Yep, so G1 shows that upper Bakken structure map for the proposed area. The map is in 25-foot intervals, deepening to the northeast, top being 8250, bottom being 8400, and you can see the type log highlighted there in the red circle.
Right. And you've included thickness isopac map. Just walk us through that.
Yep, so G2 shows that middle Bakken thickness map for the proposed area, thickening to the south in 2-foot intervals with the area of interest thickness being around 28 feet.
Okay. And you referenced the type log. Just you've got that included on G3. What are you showing on that type log?
Yep, so G3 is a representative triple combo log showing gamma resistivity and porosity.
Okay. Let's move on into E1. So with what you're actually proposing to space today, those two spacing units, how would those be developed?
Yep, so E1 shows Whiting's plans how we would develop these two DSUs. It would be 8 new wells being drilled from east to west, 2 new pad locations, what we believe would also be off of U.S. Forest Service lands.
Yeah. And then moving on to the next exhibit, E2, just walk us through the reservoir data and then what the economics would look like for those wells.
Okay, so E2 shows the reservoir and economic properties on a per well basis. Looking at the middle table, you can see the OOIP of, and do you guys have the updated one of 3.5? Are you showing 3.5 there? Or are you showing 2.4 OOIP in the middle table?
We got 3.5.
Okay, so that is correct.
Yeah.
So the 3.5 million barrels per section with an EUR of 775 MBO. And then the table on the bottom shows a capital investment of around $10.4 million with a rate of return of 73%, which is exceeds Whiting's internal metrics.
Sure. And then let's move on to E3. It was previously discussed a little bit with Taylor, but there is a lot of fed acreage, including some in your spacing units. But what would your proposed kind of plan of development look like for this township and range?
So kind of jumping on the back of that one. So the green layer here is actually shows the Forest Service layer here, Forest Service there. What we would propose here is another way to do this, including those 2880s that we're discussing now, and then 3 mile stand-ups to the south of that, and then another 2880 on the south there. And all of these, we believe that we can or should be able to find surface locations that are off of Forest Service, so we are limiting any kind of exposure, any extra disturbance that is unneeded, as well as tying in the existing infrastructure in the area.
Sure. And with the federal acreage, some of it nominated, some not. Depending on what happens with that, we don't know. Obviously, Court could get some or all of that, or none of it. Phoenix could get some, all, or none of it. So, whoever, regardless, what you're proposing today isn't going to strand any acreage, is it?
No, that's correct. And like you said, Wade, it's very dependent on what comes out of those lease sales. And this is just a proposed plan that we could come up with that is consistent with any orderly development staying within townships.
Right. And Tyler, in your opinion, then, if the commission were to go ahead and approve these two 2880s, is that going to prevent waste, protect water rights, prevent the drilling of unnecessary wells?
Yes, sir.
Okay. I don't have any further questions at this time. I'd offer the geoengineering exhibits and the gas capture plant affidavit.
Objection.
No objection.
Exhibits are admitted. Mr. Beaver, do you have any questions for this witness?
Just real briefly. Tyler, do you happen to know how the federal acreage, according to Whiting, was calculated here?
I do not know. I'm not familiar with that.
And looking at Exhibit E3, you have your 2 proposed 4-milers. They're depicted in red, correct?
Yes, sir.
And then ultimately we have producing wells that are a few sections north there in 150, 104.
Yes, sir.
So ultimately, Whiting putting 2 laydowns here, isn't that going to force people or different companies or whoever wants to come operate to get into those laydowns going north if they want to avoid inclusion of that producing acreage?
Are you referring to the laydown 2560s and 150, 104.
Yeah, the ones that you have depicted there.
Yeah, so again, this is just a proposed plan. Nothing is set in place. So
Sure.
subject to change, but this is just how we saw fit that we can maintain that orderly development within townships.
Right. But at least for 4 or 6 sections there to avoid that, those existing wells, you're probably going to have to do either a 2-mile stand up going across the bottom of 150, 104, or those laydowns as you guys have depicted, right?
Yep, something like that. Yep.
When do you guys plan to drill these wells?
So again, this is very up in the air, not knowing what's going to come out of that lease sale. It is on our current 3 to 5 year plan. We are developing to the northeast of here, working west across what we call our Foreman View area. So we would like to get on the schedule, but not knowing what's going to come out of the lease sales and working with the Forest Service takes quite some time. That,
of course,
timing is a little up in the air right now.
Yep. I have no further questions from Mr. Smith.
Redirect.
Yeah, Tyler, you're not forcing anybody to the north into any particular spacing, right?
No, sir.
So, I mean, the laydowns, that's a possibility or an option. If Phoenix or somebody else gets that acreage, they could develop, like Mr. Bieber indicated, with 1280s, right?
Sure.
And I think you heard in the previous case that Phoenix has indicated that they like 1280s with switchbacks. Pretty comfortable with those. Pretty optimistic about them. So that's an option, right?
Sir.
For whether it's Phoenix or anybody else.
Yep.
Okay. No further questions.
Any questions from staff?
Tyler, just a clarification on Exhibit E1. What's the different colors of green mean?
That is just a internal GIS odd shading. It should all just be reflecting of that green Forest Service land is the intention there. It's something with a background of like a topography compared to what's on here on the map.
Okay, thank you.
Yep.
All right, hearing no additional questions. Anything else, Mr. Mann?
No, Mr. Examiner, thank you.
Mr. Bieber, do you have any witnesses?
Yes, Mr. Examiner, we have one witness for this matter, Mr. Justin Arn.
All right.
Oh, and then we also have a set of exhibits here.
Thank you.
All right, I'll just remind Mr. Arne he continues to be under oath. You may proceed.
Yeah, Justin, are you personally familiar with the land matters that are subject to this 32737?
I am.
And do you prepare cause to be prepared Phoenix's exhibits for these hearings?
I did.
All right, Justin, can you please just give us a brief overall synopsis of why Phoenix protested?
Certainly, absolutely. I'm just going to walk through our arguments and exhibit fairly quickly. This is unusual for Phoenix. Usually when we're here protesting a case or something of that nature, we have an alternative plan to propose before the board with 2 competing applications. In this case, we don't. At this particular time, it is just a straight protest. And so I wanted to just go through that briefly as opposed to presenting a fulsome plan. And I think I'll explain why here shortly. Phoenix opposes this application because we believe that spacing of these units is premature, given the unleased federal interest in this area. It's premature both in the units that court is attempting to space, and it's premature for the surrounding units, again, given the unleased federal acreage and how soon that unleased federal acreage is going to be up for sale, not only in the near term, but also in the far term. Many of these federal tracts, a lot of them very large, have not been issued sale dates whatsoever, as we heard, in fact, in the application here by Cord. Many tracts that would disallow them from drilling their own acreage haven't been issued sale dates yet, and they're going to need to wait until they are, which is one thing. You can certainly space doing that. I think that when you space doing that and then force configurations onto the further unleased federal acreage, I think that's when potentially there's a problem there. And that's not just a problem identified by Phoenix, but I think it's also been a problem identified by the board as well.
All right, just taking a quick look at L1 and then L2.
Certainly, L1 again just shows our regional map showing the two 2880 spacing units. Sorry, that's L1. As we go to L2, we just wanted to show that Phoenix does have standing in these laydown units. You can see that the standing isn't huge. We have a small working interest percentage in both units, but we're not willing to protest a case necessarily unless we at least have some interest in the case for the surrounding area, and I think we do. We also wanted to identify the unleased federal interest in each of the units that Cord is proposing to space. You can see in the northern unit there, we're showing 12.58% is currently unleased fed. The important portion of that 12.58% is that despite the fact that Cord, with a majority, I think they have a straight majority even without cracking support, still, I don't think we'll be able to drill that until that federal acreage is leased, which I don't expect to happen for at least 1 year from now, given the sale dates that have already been issued by the BLM. Now, in the southern unit, 7, 8, 9, 10, and 11, Phoenix is showing 44.42% unleased federal interest. I don't know who's right there. Cord is claiming that between them and Kraken, they have maybe 65, 70%, I think. So there's clearly some sort of discrepancy there, but I think what we can both agree on is that there's still a substantial number of unleased federal minerals in that unit, and that Cord cannot drill that unit right now. And furthermore, they don't know when they're going to be able to drill that unit. And I don't think that's disputed.
And turning to L3, depicting federal acreage there.
So I prefer our L3, which identifies the unleased federal interest there in orange. The two units subject to this application being 2, 3, 4, 5, 6, down in 149, 104. And then, of course, 7, 8, 9, 10, and 11. And you can see those unleased tracts there in sections 3, 10, 8, and 5, specifically the ones in 3, 10, and 8, which are going to need to be not just leased, but then federal APDs applied for. But what I want to point out specifically on this is, and it was mentioned in prior testimony, is that when and if the board decides to go ahead and give Cord their spacing here, that it's absolutely going to limit the winners of the federal lease sales in the tracts just north of it into a configuration that Cord is applying for here today. Those could 100%, some of those units could 100% be set up as stand-up units. For example, from 28, 33, 4, and 9. 15, 22, 27, and 34 could be a stand-up there in 150 North, 104 West, and then 3 down to 3, 10, 15, and 22, and 149, 104. There's so many different configurations off Forest Service land that could be done here, assuming that that unleased fed does get leased, which it will, because it's all been nominated, because Phoenix nominated all of it. And we know that those nominations are passing through the BLM process, and we'll see that here in a minute as we look through the next set of exhibits. But as we see just how much unleased federal interest there is in this area, this is why we believe that that spacing these two particular units that cannot be drilled is premature. I wanted to go to Exhibit L4. Exhibit L4 shows the in-unit, what we believe is the in-unit unleased federal acreage. This is directly from the NFLSS website. This is showing sale dates not yet issued for what we believe to be, and I could have this wrong, I may have messed up here a little bit, but we show to be about 1,600 acres of nominated federal interest that a sale date has been pending, SMA consent has been requested, Surface Management Agency consent requested, but again, no sale date yet issued. These are the in-unit federal leases, the ones that are in the units that the court is applying for here today. More importantly, as we move to Exhibit L5, we show these are the federal leases in 150 North, 104 West that are currently pending. Federal tracks, excuse me, that are currently pending. You can see on the case land status, you can see that SMA consent required. We have a ready for sale notice on a couple of these. So what we're seeing is that these federal leases are beginning to work their way through the process. And some of them are being issued sale dates. And this is fantastic. Many of these were nominated back in 2025. And it takes a while, especially with a Forest Service or a SMA agency also being the Fed. But these these federal tracks are being positioned through by the BLM. And we think, and that's not just here, that's across all of grasslands. So again, what we're getting at here is that there's a substantial amount of federal interest, not just in unit, but in the surrounding units that will be affected and will be affected in terms of how those are spaced by the spacing that court's applying for here today. And there's apparently no need to necessarily space this right now, given that it can't be drilled. And then finally, we have Exhibit L6. This is a proposed development plan map. All we're doing is, from Phoenix's end, is proposing an alternate configuration. Now, Phoenix hasn't actually proposed this to the board yet because our working interest is simply too low. None of this can be drilled either, just like Chord's units currently can't be drilled. And none of it's going to be able to be drilled in reality until a lot more of this federal acreage gets leased, which we believe will be in the next year and a half. And we think at that time that it will no longer be premature to start drilling these. Obviously, operators should start looking for surface locations as Chord is, as we are, and start working together to try to produce this acreage. But again, if these applications were granted and this spacing was granted, it would certainly limit the development both to the north and to the south in ways that we think are currently unnecessary. That's our argument, and that's why we're protesting these cases.
And Justin, just real quick, going back to Exhibit L4, at least according to the BLM's records, these were pulled from the BLM website, correct?
That's correct, the NFLSS website.
Right, and so according to the BLM anyhow, the amount of unleased Fed acreage is consistent with Phoenix's L2.
We think it is, yeah.
No further questions for Mr. Arndt.
Mr. Mann?
Yeah. Mr. Arndt, Whiting testified that in the northern 2880, they have just over 80% working interest with the support from Kraken and over 70% in the southern 2880 with support from Kraken.
Mm-hmm.
So regardless of who, once those Fed tracks are leased, regardless of who picks those up, they will have the largest working interest, correct?
In these proposed spacing units, yes.
Correct. So why should Phoenix be able to dictate and determine, whether or not what they're proposing is the appropriate spacing?
I think the better question is why should Chord dictate what the appropriate spacing would be across the entire area, which is what would happen if this application was granted.
We're not, Chord, it is Chord, but Whiting is not asking to space the entire area. They're asking to space the two 2880s in which they have over 70 and over 80% with support. To the north, what interest do you have in these sections?
Phoenix has a substantial amount of interest in Section 15 of 150 North, 104 West out of the gate. We've also got small interest throughout. And Phoenix also was the nominee for all of those EOIs in that township, including paying the federal expression of interest payments to get those nominated. Not just in that township, by the way, but also in 149 North, 104 West too. I think potentially in unit and south of Court's units.
So nominating tracts for lease, that means you automatically get the lease?
Absolutely not.
And I believe in the last case that Phoenix testified that, particularly in Virgin Reservoir, that the 1280 development with switchbacks can be very promising and economic. Is that correct?
I think my engineer testified to that, yes, sir.
Okay. So there's no reason why there couldn't be any number of configurations, including 1280 development, or even larger to the north, or the laydowns that Whiting has proposed. Nobody's hemmed in, are they?
Well, they are hemmed in. There's certainly, I agree that there are a lot of different configurations that could be applied here.
Okay. No further questions.
Any redirects?
No.
Do you have anything else with this witness?
No, Mr. Examiner, that's it. And that completes our testimony and exhibits.
Mr. Beaver, I'm not sure that you actually moved for admission of your exhibits.
Oh.
Do you want those to be admitted into the record?
Yes, Mr. Examiner, we have moved for admission of all of our land exhibits. Here it'd be L1 through L6.
Any objection, Mr. Mann?
No objection.
Any questions from staff?
Justin, has Phoenix ever proposed space units with unleased federal acreage in them?
Yes.
Were those premature?
We don't think so, no.
What's the difference?
So on a case-by-case basis, I would say that Phoenix has spaced 3 units, or attempted to space 3 units in 148, 103. I want to say 148, 103. 2 of those units are actually drillable, and the third unit was just the ideal spacing given the drillability of those 2 units. So there was unleased federal interest in those 2 units. That's still working its way through the nomination process, but because of the drillability of those units, which Phoenix is currently working on, it also set a pattern up north or in that area that I don't think the ramifications were as deep on this one, or as deep as they would be on this one. Now, there was a particular case, I think it was heard 2 months ago, specific, and I don't have that case number, I'm afraid, but the board might remember it. Phoenix was I want to say a 75% working interest owner in a laydown in 149 North, range 103 West. In fact, it was in the middle of the township. And Phoenix, by spacing that laydown, which Phoenix thought was the ideal configuration, given that it would be off of, it would be the only spacing that would allow for off Forest Service surface. We thought that was the ideal configuration. Now, I will say this. Questions from the board were very specific in that attempting to space that would force spacing configurations across that entire township. And so Phoenix was at that point asked for supplementals to propose how they would space across the entire township. We met resistance from the board on that, is what I'm saying.
I would classify it as resistance. I think you were questioned about it
Oh.
because it does set up a pattern.
I think they were valid questions.
If this is premature, how far in advance, you can just speculate in an ideal situation, how far in advance would an operator want a space unit from the commission to start planning?
I wish I could give you a solid answer and say, a year and a half, when a sale date is issued or something of that nature. I wish I could give you that answer. Unfortunately, it is a case-by-case basis. Is the spacing unit that Phoenix or Court is proposing, is that going to have massive ramifications across the entire township or multiple townships? I think that's a serious consideration, whether or not that unit is drillable or not. Are those ramifications, are they necessary? What does that timeline look like? And it's going to be different for every single one of those, I'm afraid. So I don't think I could give you my opinion as to how the board should look at it, what I think the board should look at it across the board. I think that certainly some spacing applications are more egregious than others in terms of the effect that they have across other spacing. And I think that's obvious, I think.
One last question on your exhibit L6, your proposed development plan. Based on the testimony we've heard today in other cases, I noticed that at least a couple of these space units include lands that have been produced or are currently on production.
Correct.
Does that seem inconsistent?
I don't think so. I think so. These spacing units aren't here before the board today. These are just an alternative plan. I'll also note that Cord's laydown configuration that they offered is also mixing producing acreage with non-producing acreage. And while I didn't bring that up as a reason for my protest, I just didn't think that was as big a factor as the ramifications of the spacing unit itself. But I do want to reiterate my point from an earlier case, and a point that Phoenix I'm going to stand by, which is that there's absolutely no way out of mixing producing and non-producing acreage in the basin. I just don't see that in order to develop these longer laterals where necessary. I think it should depend in large part on the viability of that, whether or not there's an alternative way to do it, the working interest percentage of the operator in question, and a lot of other factors. But it's going to happen. It's going to continue to happen. And I think our stance is and will remain that if you can not mix that, that would be fantastic. And that's what we should try to do. And that's what we'll continue to request. But there's no way that can't happen. So, and development needs to continue.
Any additional questions? Right, hearing none. That will conclude the hearing for case number 32737, and the record will be closed, and we can go off the record.